Are we ready to proceed?
Yes, Your Honor, I just wanted to put something on the record, given the email chain.
Yes, and let's wait till we have him out. Of course, let's do that. You kicked her out?
She was just waiting to get.
It's like the second person that thinks that we put people in here and make a mistake. Yeah, I don't know why people feel they can't leave. It's got to be my magnetic personality. I thought. Did you call?
Yeah,
Were they listening to you?
yeah.
Okay, all right, calm down. Thought I'd ask. Why are you looking at me? I know you're making me uneasy. Where else? Court does call the case of the People State of Michigan versus Jerome Burns.
Good morning, Your Honor. Mary House, Assistant Prosecuting Attorney on behalf of the people.
And good morning, Your Honor. Assistant Public Defender Chinazi Kiriakimuni on behalf of Mr. Jerome Burns. Jerome, say your name for the record, please.
Jerome Burns. Thank you. All right. The date and time for continuation of the preliminary examination. Stanley, you may proceed.
Thank you, Your Honor. People are ready to proceed. A few things for the record, Your Honor. First of all, we have, with motion for sequestration of witnesses, we've asked all witnesses to leave. We have our first witness here present in the gallery, as well as the officer in charge sitting at the table next to me.
All right.
I don't see any witnesses on the defense side, and I don't.
Defense side. All right.
Your Honor, the second thing is, I know we've had an email chain back and forth and some communication between myself and defense counsel, and at one point the court, there was a request from defense to obtain defendant's entire phone, so the whole extraction. Defense counsel and I met, I believe it was Monday, August 4th, with the officer in charge and Detective Cargill, who did the extraction at UMPD, to essentially talk about the evidence, do a review so that we would both be ready here today. We gained a lot of information. We did review some of the evidence. However, that wasn't the full extraction. It was explained to both of us that that would be a giant file, and the detective wasn't sure if our computers would be able to handle the entire file. So at that point, my understanding was that if anybody needed to look at anything that wasn't already provided to us, and counsel can speak to this as well, but Detective Cargill was very good about letting us know his schedule so we could meet with them and go through things. And he also explained that usually in these types of cases, if there is any thoughts, concerns about there being exculpatory evidence on a defendant's phone, that would be the process. Is you would kind of walk in, meet with him, he would pull it up and review it. Again, we did some of that Monday. There has been preliminary data that both sides have. There's been an additional report called Digital Evidence Forensic Report from Detective Cargill, which both sides have and have had for a while, with the information that he gathered based on his training and experience conducting these types of investigations, he felt was associated with this case for us. There was then a request, I believe it was Thursday, August 7th, from defense counsel for the entire file, the entire extraction, and Detective Cargill started working on that. We ended up receiving a thumb drive yesterday at our office, needed to be copied for us to retain a copy and then turned over to defense. That just could not be done in time. It's a large file. Of course, we have these come in all the time and we're scheduled for hearing this morning. There was a brief moment where we weren't sure if we were going to be able to proceed today. There was never an actual adjournment request from either party. We just were kind of trying to figure out if defense needed everything, or had everything they needed to proceed today. So I emailed defense counsel, I've emailed the court, we've all been on that communication. But as of yesterday, my understanding is that we're all ready to proceed.
That is the court's understanding. I really was, well, I won't say I wasn't answering, but as it was going back and forth, I was looking for a request to adjourn and then was going to make a decision if there was one, but actually there wasn't one as I understood it. And I think as you were communicating with Ms. Wildman, at the very end of the emails, we were getting a clarification as to where we're going to go today, and that was it. Ms. Eckenroley, anything you want to say?
Yes, Your Honor, just for a bit of clarification, we did, I think it was August the 4th that we had met with Detective Cargile. But on that date, I think when at least when I went in, I was expecting the ability to view the entire file because I was told that they obviously had a copy of it. But when we went there, Detective Cargile then realized that the thumb drive that was presented to us was not, it didn't contain the entire contents of the phone. He then said that he would work on getting us the thumb drive or transferring the information from that. I wanted to clarify that because by the way it was presented, it seemed as if that request was not made by me until Thursday of last week, but it was in fact made on the date that we had met with.
The original, okay.
Correct. So we, obviously they were not able to get the entire thumb drive with the information from the phone over to us. When the people asked if we were ready to proceed, I think the question that we just had from the beginning has remained the same. Like, what are the contents of the phone? What else? I understand, and I'm appreciative of the summary that was presented by the detectives. But again, you know, this is just a summary of information that they felt was relevant to the case at hand. So that's the information that we have to go off of, which was why I was requesting whatever additional information they have so that we can have our tech professionals run whatever scans or searches on it. If the court we're in a tough position because my client is in custody. He is, you know, asking that this matter be handled expeditiously. He's asking that we continue on with the hearing, although all of that information has not been presented to us. We are at a bit of a disadvantage. I don't know how much information the people themselves have from the phone. I know that we all only have this that was presented to us by the police.
When you say this,
there was the digital evidence forensic report that was provided to us by the police department.
the time that you met?
That is
with
correct.
them? Okay,
Yes.
all right.
Yes, so I know that Ms. Tanha is in receipt of that as well. I do not know if she's had an opportunity to view the entire contents of the phone or if we're all just relying on this. I say that to say that our concern was, again, if there's any additional information on the phone that may be beneficial to us, we don't have the privilege of having that. But I have not been able to receive my client's permission to ask for the adjournment. We are ready to proceed with the information that we have, but that's kind of where we are. Which is why we didn't request the adjournment. My client wants to proceed with the hearing today, but I just wanted to inform the court that the information we have is what has been presented to us by the detectives.
I thought, and I don't have the email in front of me, but I thought there was a request regarding a PR bond. I think you asked, would the people agree to a personal recognizance bond on it and the like? That was a definite no. Very quickly came back. And then I thought you had indicated and again, I'd have to see it, that you were ready to go forward
With the
with
information.
with the information that you had.
That is correct, yeah.
Now, I will just tell you that I took that to mean that I've looked at what's there and it's sufficient to make sure that I can adequately proceed through this preliminary examination. I'm hearing something a little bit different, and I just want to make sure that what I understood you were communicating to the court was what I just said.
So, Your Honor, Judge, essentially, I think, I mean, all that the defense is saying, or that I am saying, is that I have had an opportunity to review all of the information that has been provided by the people. Knowing that there is additional information out there, I have not reviewed that. Do I feel comfortable proceeding? I don't know what is on that information, but I mean, even based on the information that has been provided to us, I don't expect anything, at least that would be detrimental to my client, but I just can't, I don't know. I cannot say that there's information that would be beneficial to my client that I've, been able to, that I'm comfortable proceeding without. If I can talk to my client a little more, but I spoke with him yesterday prior to sending that email, and his position was that he wanted us to proceed today.
Okay, all right. Yes, go ahead.
If I could just for the record, first of all, the defendant being in custody is not unique. We have defendants in custody all the time. We've had search warrants for defendants' phones all the time. I will say this, and I think this is important for the record and for the benefit of the defendant. I know this court and this defense counsel have done excellent, diligent work in being very patient with making sure that his rights are protected, making sure, as have I, making sure that we do our best to pull any threats that look like it could be potentially exculpatory, potentially beneficial to the defendant. We have turned over anything that it looked like it'd be beneficial to the defendant as soon as we've seen it. I've communicated with counsel, and she's been amazing about communicating with me throughout this process to make sure that his rights are protected. The witnesses, the victim, have been here multiple times. What is unique about this situation is the amount of work and diligence that has gone into making sure his rights are protected in this case. It is very rare to have a victim and witnesses show up this many times with this many adjournments, all truly with the purpose of protecting his rights and making sure that we don't miss anything that's exculpatory or beneficial to the defendant. To answer defense counsel's question, I have not reviewed the full extraction of the phone. It's on a thumb drive sitting at our office. There is no way I would have had time to look at that. So any information that may be on there, I don't have the benefit of, other than what we already have and what defense counsel already has. We can simply not have a situation where every case that is set for preliminary examination, we go through everything possible on the defendant's phone. That is just not a realistic expectation to have. And I know that's what the defendant wants, but we also have to work within the parameters of judicial efficiency and, quite frankly, the rights of the victim to proceed with this in a speedy manner. So at this point, again, the normal procedure as it's been explained to me, and we could put this on the record at some point if we need to, is if the defendant, and this has been asked a few times, if defendant has a specific date, folder, time, anything we can use to pull whatever he claims to be exculpatory or beneficial to him, we would certainly do so. Some of it we already have pulled, and we'll argue whether it's exculpatory or not. We'll go through all of that today. But to have this expectation that for the defendant to be able to review the entire contents of his phone that he's had without giving us any specifics or any offer of proof that is exculpatory or beneficial to him is just not realistic. So I want to make sure the record's clear about the amount of work that's gone into this case and protecting his rights.
Right, and so that this case is a little bit different than most of the ones that come before me where we're talking about this type of forensic evidence. And that is the way it arose was not because the people said we have this phone and we're kind of giving you what's here. We're not sure necessarily what's here, but we're gonna, as we unfold it, we're gonna get it to you. The way this started was really, maybe this is a bit strong, but at least a representation that there was exculpatory evidence for the defendant on the phone. And that's how this all began to unfold, which I think, at least from the court's perspective, gave me some pause to make sure that we found that, or if it existed, that it at least be uncovered, and why we kind of almost came to a screeching halt, but we did at some point to make sure that that could be gotten over. I'm a bit troubled, and maybe it was said before, but I'm a bit troubled with the fact that there aren't specifics haven't been given by the defendant as to what might have been referred to of this exculpatory evidence. I don't know that. I'm not saying it would have to be something very detailed in specifics, but it sounds like to me we haven't received anything that even tells us what ballpark we're in, so that can be looked at and gotten to the defendant. So that's a bit troublesome. But I just want to point out, for the purposes of the record, this happened in at least what has been a unique way, which is what has led us to have these adjournments and whatever. Ms. Ecker, was there anything else you wanted to say, or because I'm going to do something here, I think.
Well, nothing. Yes, Your Honor, just very briefly. And I just want to kind of echo what the court said. This is unique, primarily because this was not something that the people had, or this isn't discovery that the people had from the onset of the case. So when we set this matter for preliminary examination, I don't even think at that point, I'd have to look at the dates, but I don't think that the people even had his phone at that time. If the court can recall, the people could go. So exculpatory evidence, it was my client having a conversation with his father stating that there is some information that may be helpful to him that was on the phone, which is what prompted the police department to go get a search warrant, which we quite frankly have some issues with, but I do think that that's an issue that we can address at a later time, to get the phone. So we're here now, not because this is just your ordinary discovery process, and typically, whatever is given is given. This is information that the people went and took from my client, and has in fact, at this point, put us at a disadvantage from being able to utilize the information to the benefit of my client. He initially, what he spoke of on the phone was semi-identified. He tells me that it's not in its entirety. There's a video of some sort on the phone, Your Honor. That's what sparked this entire exculpatory evidence conversation, which is what prompted them to go and retrieve the phone. I was able to get the video, but it's a very short video. My client indicates that that's not the correct video, but I don't know how else to get that information other than the extraction from the phone, but he hasn't been able to provide us with any other information. So I don't know, Your Honor. We are kind of in a tough spot.
Your Honor, may I?
I'm just wondering, is it some other video then? I guess this is now a little bit confusing, well, it always has been confusing to me, but whoever wants to.
Sorry, Your Honor, this is the first I hear that this video, they pulled a video, and this is the first I hear that that's not the video. I'm sorry, at this point, defendant's playing games and we're not doing it. No, we're just not. I'm sorry, let me just finish, because this is important. If there is a video, they were at the hospital for 5 to 7 days at most. If there's a video, it cannot possibly be that hard to give us some specificity about what day it was at the very least that this video was recorded, or a time range or something. The video we have is from the hospital. It is very short. I agree with the defense, it's very short. And maybe defendant initially thought that was enough to get him off of this and he's gonna walk out the door with that short little video. We disagree. We can certainly have the hearing and just see where it lands. But to now show up, this is delay tactics, Your Honor. We've been here how many times, and this is the first I hear this is not the video?
No, well, Your Honor, let me just clarify. When I spoke with the people yesterday, they asked for specifics before. When I was reviewing the information with my client, and I explained to him the nature of the video that was found on the phone, he's indicating to me that it's not that it's in another area. He just says that there was, I don't know if the court can understand, when you're taking a video, you press the button, you accidentally cut it off. And
I'm not that old. Go ahead. That's all right, Ms. Eckenroley. I'll just, no.
But somehow or another, I think he's indicating that there was user error and he clipped it short. I did not tell the people this. This is information that I just got from him last night when we had met to review this.
And I'm not blaming the counsel, because I want to be clear. Like, this is not, she has been excellent about communicating with me. This is, I am concerned with the games that defendant is playing. The reason, and to now he's claiming he's at a disadvantage because we went and got things from his phone. He told us that he had exculpatory information on his phone. If I don't go get that exculpatory information, I'm in violation of Brady. So he's not at a disadvantage. We have done everything we could to find him this supposed exculpatory information, and now because it's not exculpatory enough for him, he says that's not it, there's more. It's just...
I hear you. And I guess I'm a little bit worried because I don't know that I was told that there was a video. I don't know that that's relevant to at least in part my analysis, but there's a video. They have gotten the video, and now, certainly for me, I guess it would be the first time I would hear it today. But there is then an indication, and the people are indicating the first time they're hearing it today, that's not the video. Now, I don't know if that means there was user error and the video got cut short, or that there's some other video he's claiming. That is a little bit unclear to me.
And Judge, I just want to say for the record, my client never asked the people or the police to get his phone and assist him with getting exculpatory evidence off his phone.
Well, but here's the problem. When there's an indication, though, that's made that there's something exculpatory and it happens to be in the possession or can be retrieved by the people, they're under an obligation. So it's not, I understand he may not be asking, but there are certain legal obligations that they have to fulfill. Because certainly the other argument would be made that, yes, there was this there, the people knew it, they didn't do anything. You don't want to hear that either. So here's what, and we could probably go on all day about this. I'm going to give you, Ms. Eckenroley, as I hear from you, you wanted to talk a little bit more with your client, correct? Yes. Okay, so we're going to do that. I believe that is the social worker.
Yes.
Only because I've seen her like 50 billion times here. All right. It's amazing. I'm a pretty bright guy. All right. I am going to, irrespective of where we end up with everything, I am going to take her testimony today. if for whatever reason, if it ends up this way, something comes across where she needs to be brought back, we'll figure it out. But she is not going to, I think this is your 4th time at least down here. 5? Ow. Notice how she said, it was funny, I said 4. She immediately put her whole hand up to let me know that it's 5. Okay, I'm sorry, I discounted. So I'm going to make sure that her testimony is taken today. And then if for whatever reason, something else comes up afterwards, she needs to come back down to clarify some things or some other things need to be explored, we'll deal with it. But I'm going to get her testimony out of the way. You have what other witnesses do you have?
Your Honor, the victim is here. And her son's with her because that's what we had to do.
So,
And Sergeant Matthews is here, Officer Morton's here. So we have all our witnesses that we would need.
okay, but we have 2 outside of the victim. The social worker here is the only civilian
Correct.
witness. Okay. So what I'm going to do is we'll take Mr. Burns back, give him an opportunity to speak with counsel. When we come back, my expectation given is that we will then be taking your testimony to get that out of the way. Okay?
And Your Honor, just so everybody's aware, I believe Sergeant Matthews is going to be gone. So scheduling wise, we'll have to discuss that. He's going to be gone for a bit. I'm going to be gone for 2 weeks, starting next week. So.
And I'm gone. No, I'm not. All right. Okay. We'll if we have to get there, we'll deal with it. Okay. All right. Thanks. So Court's going to stand in. All right.
Two one S 00232, the People versus Megan LeBlanc.
And Megan, on behalf of probation.
And Ms. LeBlanc, can you tell me your first and last name?
Megan LeBlanc.
LeBlanc. I'll get it one day. All right, you're here today on an allegation you violated the program. The allegations are that you failed to appear for your status hearing on July 22nd, and you failed to appear for testing on July 27th. Do you understand the allegations against you?
Yes, Your Honor.
And did you go over this 2-page advice of rights form?
Yes,
Did you understand your rights?
yes,
And did you sign and date it?
yes, Your Honor.
Megan, you understand you have a right to an attorney, and if you couldn't afford one, I'd appoint one to represent you.
Yes, Your
Are
Honor.
you waiving your right to an attorney?
Yes, Your Honor.
All right, you also understand you have a right to a hearing with all the hearing rights that are listed in this form, and if you enter a plea of guilty, you'd be waiving the rights to a hearing. You understand that?
Yes, Your Honor.
Knowing all that, to the allegation you failed to appear for your status hearing on July 22nd, how do you plead?
Guilty.
To the allegation you failed to appear for testing on July 27th, how do you plead?
Guilty.
I'll accept the pleas. What happened?
22nd, which is no excuse. I slept through my alarm that morning, and when my dad started to head towards Taylor to get me, 94 was backed up. So my dad wasn't able to get to me in time to get me right to the court. And
What about the testing?
the testing, my fiance was hit by a car the day before. Once again, I slept through my 4 o'clock alarm to check the test.
Was she home on both of these days?
No,
She was still at Angie's at that time.
Okay. Well, that makes me feel better,
yeah,
because if these violations all start occurring when you move out of the
exactly. I was-
recovery home, that would be concerning to me.
Yes, I understand that completely.
But Megan, I just don't want you distracted, right?
Correct.
What's number one?
Me. My
That's right.
recovery.
So stay on track. I was really worried these had. I didn't realize they happened while you were still at Angie's. That just makes me, I mean, you still need to, this shouldn't happen.
Right.
But it makes me a lot less worried, about you overall and the fact that you've gone back home. So, and we've had no violations so far since you went back home.
Correct.
All right. That's good news.
Yeah.
Right? Good. And I know your mom's here. I know she supports you. So, okay, you got 2 days of court watching within 14 days.
Okay,
All right,
thank you, Your Honor.
all right, Megan, hang in there. Is she okay? She can, yeah. So this Paul Brusnick case, this I'm just adjourning. That Mr. Hoffman would plead guilty, or why no contest? It says no contest. On what basis?
The basis is potential civil liability.
Who's going to sue him for having brass knuckles?
That's just it's just what we worked out with the prosecutor. And he was with other people that day who are having their own legal situations. And so we just think as a safe bet that we're going to plead no contest today.
I know, but the court rule only allows me to accept the no contest plea for 2 reasons. Is it because of other items that were found?
Yes.
All right. All right, and in exchange, all other files would be dismissed. Mr. Hoffman, do you want to take advantage of that plea offer?
Yes, Your Honor.
You understand that that's still a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500.
Yes, Your Honor.
And did you go over your constitutional rights with your attorney?
Yes.
All right, I see there's another plea as well on the no license. He would plead on that as well. Is that correct?
Yeah, in exchange for a dismissal of 2 other outstanding animal tickets, another no license, and 1 no shots.
Okay. Sir, I've explained to you the statutory maximum on this offense. You have a right to an attorney appointed at public expense. I see that you have counsel present with you today. You have a right to a trial, and at the trial, you have the following rights: to call witnesses to speak for you at trial, and you could get an order signed by the court to require the witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. And if you chose not to be a witness on your own behalf, the prosecutor could not comment on your refusal to testify. You also have a right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
And you understand if you plead guilty or no contest, and I accept your plea, you will not have a trial of any kind and you'll be giving up those rights.
Right. I understand.
Sir, you understand that if you're on probation or parole and you enter a plea of guilty, it could result in violations to your conditions?
Yes. I understand.
Okay. And you understand if you're not a citizen of the United States and you enter this plea, it could have immigration consequences up to deportation.
Yes.
Knowing all of that, sir, how do you plead to the charge of dangerous weapon?
No contest.
Is there a stipulation for me to review the police report to establish a factual basis?
Yeah.
Support the no contest plea. So I'll accept the no contest plea on dangerous weapon. And in exchange for that plea, let me ask you this first. Has anyone promised you anything, threatened you in any way to get you to enter into this agreement?
No, Your Honor.
Are you doing so of your own free will?
Yes.
All right, I'll accept the plea if you're satisfied, counsel.
I'm satisfied, Judge.
All right, and then the, let's see, 0613 is dismissed as part of the plea. D&E tickets. And then I have these two civil infractions, 842 D&E, and both of these are also being dismissed per plea. So we've got those done. And then we have this other file. See, 614, the other misdemeanor is also dismissed per plea. And then that leaves us with all of these civil infractions. And there's an agreement that if he pleads responsible on the no license, which is the 37 file, let me find that. Sir, that is in default already. So we're taking these out of default for this plea.
That's
Mr.
my
Hoffman,
understanding.
you're sure having a good day in court today. Not so sure it's deserved, but you are. So those two will be dismissed per plea, and with the default will be set aside. And then to this no license, what is that? With a fine of 212 to the allegations you didn't have a license for your animal in the city of Taylor in violation of city ordinance back on January 3rd of 2024. How do you plead, responsible or not responsible?
Responsible.
All right, that is a fine of 212. So that should resolve these matters with the exception of the sentencing on the dangerous weapon. And sir, you're going to be referred to probation for a pre-sentence report. And we will set a sentencing date. Once that's been set, you'll receive notice of that in the mail, Mr. Hoffman, within the next week. If you don't receive notice, you're to contact the court to ensure you don't miss that appointment. You understand me?
Yes, Your Honor.
Anything else?
Nothing further at this time, Judge. Thank you.
All right, we're all set.
All right, Mr. Hoffman, you're free to log off.
Okay, thanks.
Is 51490, and then I have civil infractions 25TA 12549 A, B, C, D, and F. Counsel, can I get your appearance?
Good morning, Your Honor. Paul Robinson, P number 327, appearing on behalf of Indian Summer Recycling.
Okay, so I see that Mr. Zick has offered a plea that if your client pled responsible on the A, B, and D file, so no inspection, and defective equipment with a total of 780, 30 days to pay, the misdemeanor offense and the remaining civil infractions, which would be the C and F file, are being dismissed. Is that your understanding?
Yes, Your Honor. And I do have authority on behalf of the client to plead responsible to the A, B, and D charges.
And those are all alleged to have occurred on May 16th, 2025 in the city of Taylor. I'll accept the responsible pleas on those 3 infractions, counsel. It's $780 and your client has 30 days to pay.
Thank you, Your Honor.
Thank you. Have a good day.
Thank you. You as well.
Elsie Huddy, come on up. Good morning, ma'am. This is 25174252, the city of Taylor versus Kelsey Huddy. Ma'am, can you tell me your first and last name?
Kelsey Huddy.
Huddy. Okay, Miss Huddy, I have a note on the file that the case is being dismissed because the property is in compliance. So, you're all set, and it looks like you posted a bond on this. I'm guessing it went into default and you wanted to set that aside. So your money will be refunded to you. Okay? All right, you're all set. Have a good day. On Brent Gaddy. This is 24170406, the people versus Brent Gaddy.
Good morning, Your Honor.
Hi, good morning, Mr. Gaddy. Do I know your mom?
Yes.
Okay, I thought so. How's she doing?
Good.
Good. All right, I want to just put on record, I do know his mom in my professional capacity, and I hope she is doing well. Nothing about that will affect my ability to be fair and impartial on this case. Do you have any objection to me presiding over this matter since I have this relationship with your mother?
No, Your Honor.
All right. It looks like we're just doing a 30-day adjournment so that you can get that property in compliance, right?
Yes, Your Honor.
All right, good luck. You're all set. We'll send you notice out of the new date in the mail. Tell your mom I hope she's doing well.
Thank you.
All right, thanks. Is she doing well?
Yes, ma'am.
Good. All right, Heidi Malone. This is 25174644, the people versus Heidi Malone. Good morning, Miss Malone. You've seen the routine. Can you tell me your first and last name?
Heidi Malone.
All right, Miss Malone, good news. It seems that the property is in compliance and the case against you is being dismissed by the prosecutor. Okay, you're all set. Have a good day, ma'am.
Thanks, you too.
Yep. All right, we're in a 5-minute recess. Right, 25178-054, the People versus BCSK Rental Properties.
Good morning, Your Honor. Michael M. Williams appearing on behalf of BCSK Rental Properties, LLC.
All right, I have here that there's a plea offer that if your client pled responsible on the 8054 ticket for failing to obtain a certificate of compliance on rental property, the remaining 2 cases would be dismissed per the plea. Is that your understanding?
Yes, it is, Your Honor.
Do you have authority to enter into that on behalf of your client?
Yes, I do, Your Honor.
All right, the allegation on August 1st of 25, your client had failed to obtain a certificate of compliance on rental property. How do you plead on their behalf?
Responsible.
All right, I'll accept that plea as knowing and voluntarily given. It's a fine of $160. Your client has 30 days to pay.
Okay, thank you very much, Your Honor.
And then the other 2 will be dismissed.
Yep, very good.
Thank you, counsel.
Yep, you have a good day.
You too.
Injuries giving me issues, so.
That's okay. It's not, you showed up, you couldn't do it, and now you're here. I don't have a problem with that at all.
Thank you. This is my girlfriend with me.
We've met before. Who is this?
This is my girlfriend.
Oh, girlfriend, maybe we haven't. Well, it's nice to meet you. Okay. Yes.
So, unfortunately.
Has anyone forced you to get you to plea?
No,
Has anyone promised you anything other than the plea agreement to get you to plea?
no,
Are you pleading guilty of your own free will?
yes, Your Honor.
Sir, were you in the city of Taylor back on August 4th of 2025?
Yes, Your Honor.
And while you were in the city, did you have some contact with law enforcement?
Yes, Your Honor.
All right, and were they in uniform?
Yes, Your Honor.
And how did you interfere with their authority?
I resisted, Your Honor.
How so?
Pardon me. I resisted. They tried to put me in the truck, and I said I didn't want to go in the truck, Your Honor.
All right, did you use some sort of, when you say you resisted, did you physically resist?
They tried to put me in the truck, and I tried to not get in the truck by, kicking
All
the
right.
truck or pushing myself away from the truck.
All right, I think that's a factual basis. Mr. Fanto, are you satisfied with that? All right. All right, sir, I'll accept that plea as knowing and voluntarily given. And the other 2 cases per the prosecutor will be dismissed. I am going to, how long's he been in custody?
Today would be day 10, Judge.
I do think he needs a pre-sentence investigative report. I will convert the bond back to personal. Okay. So, Mr. Jones, I just want to make sure we understand each other, and I think we probably have a much better understanding now. When I say no contact with someone and no contact with an address, what happens if you go there?
I will be arrested, Your Honor.
And where will you sit?
I will be back where I'm at, Your Honor.
So are we going back anywhere near Akila Vincent?
No, Your Honor.
Are we going anywhere near where she resides?
No, Your Honor.
Okay, I want to make sure you understand that I'm not playing with you. You cannot go back there.
I fully understand, Your Honor.
So you still have no contact, even though those, as part of this plea and as part of your getting a personal bond pending sentencing on this case, you're to have no contact with Keila Vincent, her home, where she works, where she goes to school. Don't call her, don't text message her, don't email her, don't send her flowers, don't send her anything, don't go near her property. Do you understand me?
Yes, Your Honor.
All right, and you're gonna have to, we'll send you notice of your pre-sentence interview. The probation department will meet with you.
Judge, I suggested to him, because obviously, because he was at that address, that as soon as he gets out, he needs to contact the probation department so he can set that appointment up.
Yeah, so why don't you call probation upon release? Because I have a different address for you in Farmington Hills. Do you still live out there?
No, Your Honor. That's an old address. I'm residing in Detroit now, so I won't be in Taylor.
All right, but you'll be in Taylor for your appointments and your sentencing, right?
Yes.
All right, here's what I'm writing. Just so we're clear. So I'm releasing you, I'm converting your bond back to personal. You have no contact with Akila Vincent, her homework, school. You're to call probation upon release to set up your probation appointment. And you're also to provide a new address, because the address we have on the files for you is that Farmington Hills address. And I want to make sure you get your mail. Okay?
Okay, yes.
So make sure you call upon release so you can do what you need to do for this court and move on.
Yes. There's a lot of noise in the background.
All right, one sec. And we're gonna put you in the breakout room with the clerk. So if you have a new address or that address in Detroit, you can give it to her now, okay?
Yes.
All right, Mr. Jones, you're all set. We'll see you back for your pre-sentence interview and sentencing.
Thank you, Judge.
Thank you. Okay. Mark.
We do it with Mr. Farnham.
This is, no, but Mr. Jones, you're still gonna wait because you're still gonna go in a breakout room. Okay.
Yeah.
With the checking clerk. All right, gotcha. All right, this is 250055, the people versus Richard Farnham.
Morning, Your Honor. Jeffrey Fantz on behalf of Mr. Farnham, who's president. Mr. Regner is also president of the courtroom. Complainant in this matter. Judge, we're having difficulties regarding the insurance issue. Mr. Zick is going to, Mr. Farnham's made some efforts. Mr. Regner's made efforts and they were rebuffed, unfortunately, and Mr. Farnham has apologized for that. It wasn't his fault that people acted that way. Mr. Zick is going to attempt to go through his channels to determine whether there was insurance on the vehicle. The people who are carrying the insurance are refusing to provide information. So Mr. Zick's going to follow up. We just asked him to be put for 60 days.
All right. I recognize you. You've been here way too many times. I understand that this is just an issue, and I want you to understand I can't force them to comply. So it's not that if I had the authority to do that, I would, but I don't. So we are going to adjourn it out 60 days. Sir, can you tell me your name one more time?
Oh, James Regner, R-E-G-N-I-E-R.
N-I-E-R. And I'm writing on here, and I know you've been in contact with Mr. Zick. Is that correct, the prosecutor?
Very, very little. But
Okay, well, he is, Taylor's busy, but you have had contact, and you have his email information to provide documents to?
Yeah, he's provided documents. We've got the documents. The issue right now
Is
working on the
insurance. Okay, so you've provided everything you need to show us on your damages?
Not yet. It's yet to be finished.
Okay.
And some of it, he's still working on it,
Okay.
but the insurance issue is.
All right, Mr. Regner, I just feel bad because you keep coming to court on this, and I don't want you to take time away from your life, family, business to keep showing up.
You have to understand that this is just bigger than this little damage at the building.
I understand.
Okay, because insurance companies don't lose money. So if he doesn't have insurance, it resets my ability to shop insurance.
No, I understand. I did personal injury work for a minute. I do want, I understand. I just want you to know we're aware, and I have it all in the file. And every time I see the defendant, I know what we're here for at this point.
Well, one more time, but if it doesn't happen, then you know, the simple claim on this building is exceeding $50,000. The insurance company paid $23,000. Their slice, this is where we're at today. Okay.
Okay.
The windows are being put in on the 18th, which is Monday. Again, it's not the $20,000 difference between the insurance or the $30,000 between the insurance and the actual cost. It's what it's going to cost me over the next 5 years because
of the claim. I hear you on that. I can't give you speculative damages in restitution.
Thank you.
But we'll adjourn it for 60 days, and hopefully Mr. Zick, the prosecutor, can use whatever means he has available to him to locate that information.
And Judge, I certainly don't anticipate having a hearing. I appreciate this is what it's set for. So Mr. Regner could up here by Zoom if that works out for him better. He's provided the information and he can continue to do so, but that's certainly his choice, but we would have no objection to that.
Okay. Yeah, so you can appear via Zoom, and on the notices you get it, or you can come in and hang out with us, that's fine. I just don't want to take up, and I'm writing kind of appear via Zoom. All right.
Could Mr., again, because of the same circumstances, could Mr. Farnham appear by Zoom too, Judge? Because this is just a matter of we're just trying to get information.
All right.
Thank you.
We're all set. Thank you. Okay. Council on Marble and Granite Express. And this is 25175317, the city of Taylor versus Marble and Granite Express.
Yes.
Yes. Good morning, Your Honor. Peter Zingas on behalf of Marble and Granite Express.
Okay, so I have a plea in front of me that indicates that if the, it sounds like the inspection's scheduled for next week, and with a plea of responsible with 14 days to pay, the prosecutor would reduce the fine to $80, so he's cutting it in half. Is that the agreement between the parties?
Yes, Your Honor.
And do you have authority to enter into that on behalf of your client?
I do, Your Honor. My client is also participating. I'm sorry, Judge. My client is also in this.
Yeah, and I see them present. To the allegation, your client, Marble and Granite Express, violated city ordinance by failing to obtain a certificate of compliance on rental property on the date of May 6th to 25. How do you plead on their behalf?
Responsible, Your Honor.
All right. I'll accept the plea. That's a fine of $80, and they have 30 days to pay.
Thank you, Judge. Appreciate it.
All right. Thank you.
Ms. Edwards, how old are you?
I'm 26.
How far did you go in school?
The 12th grade.
Are you able to read and write English?
A little bit, yeah.
Are you under the influence of drugs or alcohol?
No,
Are you taking any medications?
no, sir.
Are you a United States citizen?
Yes, sir.
We've had some discussions about this case. If you enter a plea of guilty to this charge or these charges, I'm not going to sentence you today because I don't know enough about you and I don't know enough about this case yet. What I'm going to do is conduct a level 2 pre-sentence investigation. I'm going to set this for sentencing in about 6 to 8 weeks. I have no idea what I'm going to sentence you to, Ms. Edwards, so I think we can agree that it is not possible for anybody to have promised you anything about what your sentence is going to be. Is that true?
Yes, sir.
Has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. It looks like on the 3rd page is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Engel before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You said you were able to read and write English a little bit. Did he read to you any of the parts that you weren't able to understand?
Yes.
Are you satisfied that you have a full knowledge of what's contained in this document?
Yes, sir.
You're going to be entering a plea of guilty to a couple of charges, well, 3 charges that carry with it an indefinite sentence. That means ultimately you are going to receive both a minimum term and a maximum term. The minimum prison term is going to be selected from the range. The maximum prison term then is going to be usually one half of or 50% of that. So for example, if I were to give you a 5-year sentence, I'm not saying that I'm going to, but it's a nice round number. If I did, I would give you a 5-year, that would be your minimum term. Then we would add 50% to that. That would be 7.5 would be your maximum or your indefinite term. It's presumed that you're released at that minimum term, but the Department of Rehabilitation and Corrections may, under certain circumstances, keep you up to the maximum penalty if you don't behave yourself while you're in the institution. So this is what we call a Reagan-Tokes sentence. In addition to that, you're also subject to registration requirements as a violent offender, and you are also subject to a mandatory period of post-release control of anywhere from 18 months to 3 years. There is no mandatory prison in this case. The kidnappings are second-degree felonies, means they carry with it up to 2 to 8 to 12 years in prison. There is a presumption that I would send you to prison for that. And the robbery is also a second-degree felony. It's punishable also by up to 2 to 8 to 12 years in prison. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yeah.
Mr. View, did we talk to the victims in advance of today's hearing about this negotiated plea agreement?
We did, Your Honor, and I confirmed with Ms. Kennard about her most recent contacts with them. We're prepared to go forward today.
All right. What are the facts?
Before we go on that, I just wanted to clarify, Judge, on page 2 of the plea form under indefinite term Reagan-Tokes, I had included the indefinite term at the top on page 1, but there is a blank space there to list the maximum indefinite term. So if you wanted to fill that in with 12, it was listed earlier in it.
Oh, yeah, that makes sense.
I had neglected that blank space there. In terms of the facts, Your Honor, if we were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on April the 27th of 2025 in the city of Mason, Warren County, state of Ohio, that the defendant did by force and while attempting to cause physical harm to another, commit the offense of a theft of a motor vehicle, and in doing so, remove the 2 juvenile victims from the place in which they were found.
Anything on those facts, Mr. Engel?
No, Your Honor.
Ms. Edwards, did you hear those facts?
Yes.
Do you admit that they are true?
Yes.
Do you understand the rights you're giving up by entering a plea?
Yes.
What's your plea?
But I didn't touch them.
Okay.
I didn't touch the kids at all.
Okay. With that clarification, what is your plea to these charges?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. We're not going to go into the matter of the sentence today. I'm going to order a level 2 pre-sentence investigation, also an evaluation to determine whether or not you are appropriate for a community-based corrections facility. We'll see everybody back here for sentencing in about 8 weeks. Anything else?
Oh, yeah.
No, Your Honor, thank you.
All right, that's all.
All right, court recalls case, People versus Burns.
Mary Kavanaugh for the people. And Assistant Public Defender Chinazi Carey earlier on behalf of Mr. Jerome Burns. Mr. Burns, state your name to the record.
All right. And Counsel, you've had an adequate opportunity to speak with the client.
I have, Your Honor. I've had an opportunity to speak with Mr. Burns again. Thank you for that short recess, Judge.
It wasn't short, but go ahead.
Thank you. We did have an opportunity to speak. I listed everything out for Mr. Burns. Mr. Burns understands exactly where we are. He understands that I have not had an opportunity to retrieve or review the entirety of the extraction from his phone. He is asking that we proceed with the preliminary examination, knowing that that information is not available to us right now. If I could voir dire him, maybe the court would be satisfied with that as well.
Okay.
Okay.
Go ahead. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give before this court will be the truth, whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, go ahead.
Thank you, Your Honor. Mr. Burns, you and I have spoken on a number of occasions about the contents of your phone that was taken by the police. Is that correct?
Yes.
And you understand that they had done a dump of the information from your phone or an extraction of the information from your phone. Is that correct?
Yes.
You understand that we have what is considered as a preliminary or summary report that was provided to us, specifically entitled a digital evidence forensic report that was provided to us by the police. Is that correct?
Yes.
All right, and you know that this digital evidence forensic report does not reflect the entire content of your phone as it is currently. Is that correct? And you understand that because of that, I haven't had an opportunity to review the entire contents of your phone.
Yes.
Okay, and you feel that you are prepared or you feel comfortable proceeding with the preliminary examination today, although we have not had an opportunity to review the entirety of the phone?
Yes, I do.
Okay. And you understand that I would prefer that we do that, but you want to continue with your preliminary examination today, is that right?
Yes.
All right, very good. That's satisfactory for the court. Okay. That being his choice, you may call your next witness.
Excuse me, Your Honor. People call Leah Hollier to excuse.
Ma'am, please come forward and be sworn.
Take a seat, Your Honor. Do you solemnly swear to affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God? State your first and last name for the record, please.
Yeah, Leahhollier.
You may inquire.
Thank you, Your Honor. Ms. Hollier, could you please tell the court where you work? Okay, and what is your position there? Were you working in that capacity on May 10th of 2025? Could you please share with us a little bit about what your duties include as a social worker at the Michigan Medicine Hospital?
I provide resources, support, education, any needs after hours that patients and families need.
And did you have the same or similar duties on May 10th of 2025?
Yes.
On that date, were you asked to talk to Madison Burns?
Objection, Your Honor. She wants her to testify to hearsay. She asked her if she was asked to do something.
It's a question, not a statement. You can answer yes or no. That wouldn't be hearsay.
I'll agree with that. I'll overrule the objection.
Thank you.
Yes.
And were you able to make contact with Ms. Burns and speak to her? Could you tell the court a little bit about how that came about?
I got paged, the nurse was worried about.
Your Honor, it's not for the truth of the matter at this point. It's for the effect it had on the.
As to her state of mind.
Yes.
For why she does what she does. So I'll overrule the objection. I'll allow it. Go ahead, ma'am.
So I got paged. When I spoke with the nurse, she said that the patient's mom looked
Yeah, I want to object again. I don't think that she would be able to testify to what the nurse said the patient's mom looked like. I mean, it's speculation on whatever it is the nurse may have felt was going on. I think if that's the case, we should have brought in.
Let's do this way. Ma'am, someone told you about the patient, which is the child, their mother, correct?
Mm-hmm.
And is that a yes?
Yes.
Okay. And because of that conversation that you had, you then did something, correct? All right. I think that gets us through that.
Yes, thank you.
All right, go ahead.
Thank you. What did you do based on the conversation you had with the nurse?
I had a medicine in a consult room.
And when you saw Madison, what was her demeanor?
She was like visibly shaking and like she appeared to be that her shoulders were forward and she was looks like meager, I guess. She sad.
Look, I'm sorry, what was that last one?
Sad.
Got it.
And what was your understanding? I'm not asking about what anyone said at this point, but what was your understanding of why you were meeting with her?
So the nurse told me she was worried about the patient's mom.
Okay. And you said you met with her in the consult room?
Yes.
How did you first approach Madison? Where was she? Where were you as you approached her?
She was sitting at the table in the consult room. I knocked on the door and I walked in.
Okay, so you didn't bring her there. Your contact started in the consult room with her. Okay, thank you. Based on, again, not going into what anyone said, but based on the conversation, the information you had received from the nurse, did you take steps to make sure that Madison was alone with you?
Yes.
Before coming to the consult room, well, let me ask this. Madison's son, the patient, Benjamin Burns, is that correct? Okay. He was being treated at the hospital at the time?
Yes.
Okay. And what was the setup for his treatment? Did he have his own room? Was he somewhere else in the hospital?
Yes, he was admitted to the allotted floor in a private room.
And who had access to that private room?
Anybody.
Okay. In addition, I should have asked that better. I'm sorry. In addition to the medical staff, who else was there?
So before I met with Madison, before I came to the floor, I looked into the chart to see if it was bedside. That's like standard protocol. And so I read that both parents were bedside.
And is a standard protocol, yes, that's the right way. With the information you received from the nurse, is a standard protocol to, actually, let me rephrase that. With the information you received from the nurse, what is the standard protocol you would follow based on that information?
So for the reason for the referral, then I need to figure out what's going on with the patient, why they're admitted to the hospital, and read in the chart for any other past social work notes to see what I need to know before I go.
Okay. You said you had a conversation with the nurse and received some information that led you to speak to Madison, the mother of the patient. What was the nature of the concern from the nurse?
All the nurse said that Madison looked like.
Your Honor, I think this has been asked and answered already.
I'll sustain that objection.
Yeah, so the nurse said that she was.
Hold on.
Sorry. That means to stop for a minute. I'm gonna, sorry. So, when you receive information of the nature that this call was from the nurse regarding Madison, the mother of the patient, what is standard protocol to follow after you receive that type of information?
To look into the chart, to read any past social work notes, to gather the information I need to be able to meet with the patient.
Okay, and were there any past social work notes? Okay. What is the procedure after reading the notes?
To assess the situation and provide support and meet the needs of the patient's and families.
Okay. Without going into what the nurse specifically told you, what was it that you were trying to assess at that point? What's in your mind? What is your job to do at that point?
Assess Madison's coping and safety.
Okay. And where did that concern come from?
The social work notes. Sure.
Okay. She appeared sad. She was kind of hunched over. And I believe you said she was, and correct me if I'm wrong, that she was shaking.
Yeah, she was like shaking and like picking at her fingers and just like really like into herself and just like kind of like, I don't know, it's like really front.
Did she volunteer anything to you about why she was upset?
Madison told me objection, Your Honor.
Your Honor, at this point, this is excited utterance. She's testified that the victim was shaking. She was visibly upset, and we're getting into why she was upset.
Your Honor, this is not an excited utterance specifically because that wasn't her reason for going there. There wasn't an incident or anything that had happened. She just said that she was sent there to check on her. This can't be excited utterance. There hasn't been enough foundation laid to say the time frame from when.
Why wouldn't it be a present sense impression of what Madison may be thinking at that moment?
She wants to tell what Madison told her is what the testimony she wants to, is what the testimony, that's the testimony she wants to provide to us today.
What I'm going to do is I'm going to allow it and then I'll make a determination as to whether or not I'll take it into consideration. Go ahead.
Thank you. You can proceed.
Madison told me that her and her son were staying at a domestic violence shelter, and but the CPS worker had met with both of the parents when the Benjamin got admitted to the hospital, and both parents were allowed to stay at bedside, but she didn't feel comfortable with Dad being at bedside anymore because he wouldn't let her have conversations by herself, and she was trying to talk to the advocate, and the dad wouldn't let her talk to the advocate alone. They wouldn't let her leave the room.
Yeah, I just want to object again to hearsay. This is a whole narrative of what is being told. I still have not seen the present sense impression or the excited utterance behind the testimony that's being given.
And Your Honor, I believe we may be getting there, but if I may lead a little bit, I can really narrow it down.
I'll allow a little more lead.
Thank you. Did Madison tell you or make any statements to you about anything that someone had done to her body physically or otherwise while she was at the hospital?
Yes.
Okay. Can you please tell the court about that?
She told me that Friday that she had sex with her with the father of the patient.
Okay. And did she make any statements about how she felt about that?
She didn't want to have sex with him.
And did she make any other statements about what her feelings or her mindset was about what had happened?
She said that it's happened in the past.
Your Honor, just one more time. I will be remiss if I do not make the objection. We still have not gotten to the excited utterance. She's testifying about something that happened Friday. The date in question that she had this conversation with Madison was on Saturday on 5/10. So this isn't about something that had just happened that
Madison was still clearly upset about, and it wasn't a present sense impression. Madison was not explaining anything to her as it.
Well, but wasn't she explaining to them?
As it was actively happening. That's my understanding of the difference.
Well, while they're under the, okay, I see what you're, well, one might argue that, but your objection is to the hearsay of what Madison said.
That's correct.
Why wouldn't this be permitted? Because in essence, she's obtaining medical care or making for the purpose of her own medical care or psychological care.
Your Honor, I don't think that, I mean, at least the testimony that's been provided today, she did indicate that she went in and introduced herself, but I don't, there hasn't been any information that was given to us to lead us to believe that either Madison sought out this medical care or that she was.
Oh, does she have to seek it out, or can it, as it seems to me right now, it was basically a referral to the social worker from other medical staff, for which she then goes into some psychological treatment. Why wouldn't that fall into this exception?
I'd like to know a little bit more about social workers training and see if she's even equipped to handle any type of psychological issues or what purpose she was serving in her conversation with her. I think she said initially she is just there to, I don't think I wrote down her exact words, but essentially to check on the needs of the patient. And
the well-being of the patient. Yes, but I guess what I'm saying is the issue is really with hearsay is the reliability of what somebody's saying. And so if Madison is giving these statements for the purposes of obtaining care, why wouldn't that fall under the exception to the hearsay?
We just maintain our objection. I don't think that there's been any evidence or
testimony. Noted, I will allow the testimony under that theory, as well as I think that present sense impression may apply, even though it may be some time period, she may still be under the exposure or senses of what had just transpired and is relating that. So go ahead.
You can go on if you remember where you were. No. Okay, no problem. We did a lot of talking. So did Madison share with you how she felt about the sexual contact she had with the father of her children? You already testified that she didn't want to do it. What else did she share with you about that?
She said in the past, it's happened before, and she knows that there'll be repercussions if she doesn't allow it to happen. And then she also said, after it happened, he made some comment like, are you mad at me for making you do that?
Did she mention what repercussions? What happened? Was Mr. Burns, and I'm sorry, who she was talking about, did you mention him by name? Or did she just say child's father?
I mean, when I'm talking with the person that is dad.
Okay. And who do you know who dad is, who Benjamin Burns' dad is? Okay. And was he still there at the hospital?
From what I know, but I've never met him.
Okay. After speaking to Madison, what did you do next, if anything?
So I assessed the safety, and I worked with the medical team, and we contacted security, who contacted the police.
So when you say you assess the safety, how do you normally do that?
To assess safety is just if she felt safe with having dad at bedside. According to the church, because CCS was involved, dad was allowed to be at bedside if he was acting appropriately. And so that's like what I was there to assess, if that was acting appropriately.
Okay, and what was your conclusion? Excuse me.
He was making, what Madison told me is that he was making her sleep with him in the bed, and he was making her wear her wedding rings, and he wouldn't let her make phone calls without him being present, and he wouldn't let her leave the room without him.
At any point, sorry, one moment, Your Honor. Were you or security able to keep Madison separate from Mr. Burns after that? Okay. At some point, did you At some point, did she leave the consult room to go back to the room where Benjamin was?
After Mr. Berg had left.
Okay. And was she able to eventually retrieve her items that she had in the room?
So she was very concerned about getting her items from the room. So she asked me numerous times about getting her purse and her phone and her items in her bags. And she was like giving the descriptions of them. And so we asked her nurse, her nurse would come back and forth into the room. And so she asked her nurse to get her things and she could not find her phone. She left back like a lunch box and her backpack and all these different things. We could never find her phone. Or the nurse could never locate her phone.
Your Honor. And just to clarify, I believe you already said this, but did you ever see Mr. Burns? Thank you. Nothing further at this point.
Before we begin, I just want to be clear. She was concerned about, she's in a different room. She's concerned about the items that she's left in her son's room.
Yes.
Correct. And that, and correct me if I'm wrong, that the nurse or hospital staff went and retrieved her items and that, and that everything was retrieved, but except for her phone. Or
yeah, well, so the nurse retrieved everything that Madison asked for her to get.
okay, but one of the things that she was asking her to get was her phone. And is it your understanding that was the only thing that Madison asked for that that they were not able to retrieve?
Yeah, and I think from what I remember is that the nurse asked the dad for the phone and he said he didn't have it.
Got it. Okay. Cross-examination.
Hi, Ms. Hollier, how are you? My name is Tanaza. I'm with the Public Defender's Office representing Mr. Burns. I have a few questions for you, okay? All right, so you know what time this was that you said you met with Madison on May the 10th. You know what day of the week that was? That was Saturday. Do you know what time?
Well, my shift starts at 4, so it was like shortly after my day, like 5 or 6.
Okay. And you said when you went into you called it a conference room? The consult room.
It could be conference room.
Sure. Madison was in there by herself. Okay. And you stated that was on and when you went in there, no one was around the room, no one was in the room. Is that correct? Other than Madison, obviously. You indicated that this was on the 11th floor?
I'm pretty sure. Please.
Can I ask what you're looking at?
This is the face sheet for the patient, but it's not from the admission. This is just there. So
Will that refresh your recollection as to what floor you were?
I'm pretty sure it was 11th.
Okay. All right. Do you remember speaking with the police on that date? Okay. And do you remember telling the police that you had to separate Madison and Jerome? Do you remember telling them that? Okay. I have a police report that was drafted by the University of Michigan Police Department. If I can show you the section where your interview took place, will it help refresh your recollection on the contents of your conversation with the police? Yeah. Thank you.
Yes, you may approach. Go ahead. No, it's okay. It's all right. No, go ahead. Yes. Go.
Yeah, I apologize. Thank you. I'm sorry. This is such a time. Okay. You said that this in the report must have been a misunderstanding? Okay, what is the misunderstanding?
I've never met.
You've never met my client, is that correct? Okay. And you'd never met Madison before, right? Okay, so the posture and the demeanor that she exhibited on that day, you don't know if that's just her baseline demeanor, right? Okay. And you stated that she reported to you that she had had sex with my client on the day before, being that Friday. Okay. But then you also indicated something about the report, the chart, that since there's CPS involvement, that the chart indicates that my client is allowed to be in the room as long as he behaved appropriately.
The CPS worker, that was the safety plan, yes.
That was the safety plan that was provided to. Okay, and you didn't give a copy of that safety plan to the police when you met with them?
That's not protocol.
But you didn't talk to the police. You didn't inform them that there's a safety plan in place or anything else of that nature. Is that right?
I told them that there was CPS involvement.
Do you remember telling the police that my client was extremely upset because Madison had left the room?
Yes, I do, because that's what the nurses were reporting.
But you didn't see my client? Okay, you didn't have any interaction with him at all? And Your Honor, I don't think I have any more questions for this witness.
All right, thank you. Any redirect?
A brief follow-up, Your Honor. Ms. Hollier, you were asked about knowing the victim prior to this incident. You indicated you did not know her. But you also testified specifically to what you saw and your impression of her demeanor. Could you tell the court a little bit about your training and experience and how that helps you in doing your job and doing these assessments?
Well, I'm a clinical licensed social worker, so I've been doing this job since 2016. So I very often assess the safety of patients in the hospital. I have a lot of experience doing it. So when someone's distressed or upset in the hospital, I provide support and center safety. I work with CPS and families regularly. So part of my job and normal protocol.
Thank you. And you were asked about the CPS report and the safety plan that allowed Mr. Burns to be bedside as long as he behaved appropriately. What was that CPS report regarding? What was the background of that?
Well, because
Your Honor, I want to object to this line of questioning primarily because this is going to require Ms. Hollier to get into details about cases other than, well, specifically the out-of-county cases that we talked about at our first preliminary examination on our first date.
Why do you say that?
The safety plan that she's speaking of, the CPS case, those are going to all stem from something that does not have anything to do with Washtenaw County.
No, but hold on. So what are you objecting to? I guess if she relates that to the court, what is your objection?
Your Honor, I would say that, I mean, I'm going to object based on relevance. I don't think that the details of the CPS plan would be relevant to this case at hand and what actually happened in the hospital room.
Well, I think, first of all, Ms. Hollier brought up that there's a safety plan in the charting and that she had been looking at that. I'm a little bit curious about your objection because then you specifically attempted to begin questioning Ms. Hollier on whether or not the safety plan, she had communicated that to the police. So the fact that you question on that, I'm going to allow the people to question on the nature of that safety plan. So I'll overrule your objection. Go ahead.
Thank you, Your Honor. And again, the question was about the safety plan. If you could relay that to the court, please. Sure. We're talking about the CPS report and the background and the safety plan that you mentioned. What was the safety plan? Where did it come from? What was it? What did it contain?
Well, in the chart, the social worker wrote that there was a history of domestic violence and CPS was involved due to the child witnessing domestic violence. That appeared that the child and the mom were staying at a shelter and dad did not know where they were currently staying. But due to the patient being admitted to the hospital, that CPS was allowing dad to stay at bedside So that's an exception, right? Normally, during a shelter, dad's not with them, but because the child was admitted, that's the exception. And so, and the exception is that as long as he behaves and was acted appropriately at bedside. So this safety plan is that he has to appropriately.
Thank you. Nothing further.
Anything else?
No further questions.
Okay. Ma'am, thank you. Thank you for your patience. We appreciate it.
And may she be excused, Your Honor?
Any objection?
I don't have any objections, Your Honor.
This witness is excused.
Next, Your Honor, people call Officer Morton.
Sir, please come forward, be sworn.
See, raise your right hand. You solemnly swear to affirm testimony you about to give the truth, the whole truth, and nothing but the truth, so help you God. Say so your first and last name to the record.
My name is Officer Aaron Morton, Aaron, E-R-R-O-N, last name Morton, M-O-R-T-O-N.
You may inquire.
Your Honor. Officer Morton, could you please tell the court where you work?
I work at the University of Michigan as a police officer.
Thank you. And were you working in that capacity on May 10th of 2025?
Yes,
And specifically, were you working on duty that day?
I work, yes.
Thank you. And if you could tell the court just briefly what your duties include in that capacity.
In that capacity, my duties include traffic enforcement and also attending to dispatch calls for criminal investigation.
Okay. And does that involve Michigan Medicine, the hospital?
Yes.
Does that involve Mott Children's Hospital?
Yes.
Okay. And on that date, were you called out to Mott's Children's Hospital in the evening around 7 o'clock p.m.?
Yes.
And what was the nature of that dispatch?
Initially, I was dispatched to a trouble with subject call at Mott, 12-4 of Mott. Upon arriving at Mott, quickly learned from people on scene that there was more to the call than just trouble with the subject.
And as you received the call, were you informed of who the subject was that there was trouble with?
Yes, after I got down on scene, I was, briefed by the hospitals that were there. They advised me on, who was there and on the floor. And so,
And did they advise you as to who the subject was that they had called about?
yes,
And who was that person?
it was Burns. It was Burns.
Thank you. Did they indicate to you what the trouble was?
Yes, they did indicate what the trouble was. As I spoke with hospital security and also the social worker who was there, I learned that it was a little bit more than just general trouble with someone at the hospital being upset about something.
Did you at some point make contact with Mr. Burns? Visually saw him, in-person contact? Okay. Do you see him in the courtroom today? Could you please point him out and describe an item of clothing he's wearing?
I'm sitting right there, front seat, wearing a orange jumpsuit.
Thank you. Your Honor, may the record reflect that the officer pointed to defense table and identified the defendant.
That objection record shall so reflect.
Thank you. So you said you initially spoke to, well, let me ask this, who was the first person you spoke to when you arrived at the scene?
So the first person I spoke to that had all the details of what was going on was the social worker.
And who did you speak to after that?
After speaking with the social worker, I spoke with Madison Burns.
Do you remember what Mrs. Burns' demeanor was when you spoke with her?
Can you say that one more time?
Sure. What was Madison's demeanor when you spoke with her?
She seemed really timid, really like kind of in distress, like really just really kind of scared about what was going on.
After speaking to Madison, what did you do next, if anything?
After speaking with Madison, myself and other officers made contact with Mr. Burns.
When you made contact with Mr. Burns, where was he?
He was in top floor, I can't remember exactly the number, but I believe it might have been 6, but he was in one of the rooms at my children's hospital. Patient rooms.
And did Mr. Burns agree to speak with you?
Yes.
And did you then continue to speak with him about what you were called out for?
Well, we moved to another room that was more private. And then more private areas.
Okay. Did you read him his Miranda rights?
Yes, ma'am.
Okay. Did Mr. Burns make any statements to you, if you remember, about Madison Burns's demeanor or personality?
He did make full statements, trying to refresh my recollection, but I believe he was made comments about her begging regarding the situation of having sexual intercourse, and then also too, there was another part of our discussion where he made a comment regarding her being easily coerced. You know, that he's been with her for approximately 7 years. So.
Thank you. Sorry, Your Honor, if I may have a moment.
Yes.
After speaking to Mr. Burns, what did you do, if anything?
After speaking with Mr. Burns, we placed him under arrest.
I do nothing further right now.
All right. Cross-examination.
Yes, Your Honor.
Officer Morton? Officer, right? Okay, good afternoon. My name's Chinaza. I've got a few questions for you. I'm the defense attorney representing Mr. Burns, okay? You indicated that you read my client his Miranda rights. At what point did you read him the Miranda rights?
After we moved from the patient room to the private room.
But did you talk to him at all in the patient room before then?
Yes, we did.
Okay. And what information did he give you in the patient room?
Patient room, we were trying to let him know that we were there to talk to him about the situation going on there in the hospital. And then we advised him that we could move to a more private room. And our concern was the child wasn't in case anything went sideways, we want to not be around the child.
Okay.
We moved to a private room.
So you're saying that he didn't say anything to you before you all moved to the private room?
I can't recall if he said anything on the page, but
Okay.
he read him Miranda rights once we got to the private room.
Okay. And you said when you spoke with Madison, she seemed distressed. Excuse me. She seemed distressed and scared. Obviously, you had never met Miss Burns prior to then, right?
No, I did not.
Okay. So you don't know what her demeanor is on a normal basis?
No.
Okay. And you stated that this happened on the 12th floor. Is that correct?
That's what I recall.
Okay. All right. And when you talked with my client, did you did he tell you anything at all about the date? Well, I'm sorry. Did he tell you anything at all about his Miss Burns, Madison, that is, having relationships with other men?
He did.
I'm gonna object, Your Honor. It's hearsay at this point.
It's my client's statements, Your Honor, and I think that it goes to specifically?
That's why it's going to be hearsay if you're offering it.
Not necessarily. Well, Your Honor, Officer Morton previously testified to my client, telling him that, you testified that he said that she's easily coerced. Is that what you? I apologize, Your Honor. Okay.
I'm saying objection, you can go ahead.
Thank you, Your Honor. What was my client's demeanor when you spoke with him?
He seemed very surprised.
Okay. Was he cooperative with you?
Yes.
And he denied the allegations, right? When you spoke with him?
Regarding, yes, he denied that.
I'm gonna, you wanna object him again if we're gonna get into specifics. I understand the answer yes or no, but I limit it now.
Yes, he denied that.
Okay.
Thank you.
And when you spoke with Ms. Burns, is it true that, well, okay, so let me do this. You drafted a report after your interviews and investigation with the individuals involved in this case, right? And your report is a reflection of the information that was provided to you. Is that correct?
Yeah.
It's also a reflection of the information that you relied on to make a decision to arrest or not arrest. Is that correct? Okay. And when you spoke with Ms. Burns, you were provided with information as to the reason that she decided to agree to the act. Do you recall that?
Agree to the act.
Having sex with my client.
I'm gonna object, Your Honor. This is hearsay.
Response.
Your Honor, I'm actually using it for more so, this is partly the reason that Officer Morton decided at that time to bring the charges against my client or to arrest him. This wasn't just a simple, my husband and I had sex. It was information that was given to him by the complaining witness in this matter that led him to believe that a crime had been committed.
Are you asking about her statements or his statements about her statements?
No, her statements directly to the officer.
I understand that it may, given the testimony that has come in, I'm going to allow it in this instance. So go ahead.
Thank you, Your Honor. Madison admitted that she did have sex with my client. Is that correct?
That's right.
And she said she did it out of fear. Is that correct? Okay. Fear of him hurting her or their son. Is that correct?
That's right.
And that was information that you relied on.
That's right.
But she didn't tell you that he forced her to do anything, correct?
She basically stated that he had been touching her unwillingly when she didn't want to touch him.
Okay.
Since he's been there. And then over time, being in our hospital, the touching continued and the asking to have sex continued. She advised that she did not want to have sex with him, told him that he did not want to have sex with them. And then it got to a point where she gave in out of fear of being harmed or her child being harmed.
Okay. No further questions, Your Honor.
Any redirect?
No, Your Honor.
Officer Morton, thank you very much, sir.
And also be excused, Your Honor.
Any objection?
No, Your Honor.
All right, the officer is excused. Any additional witnesses for the people?
And we would have two more witnesses.
Two more?
Yeah.
Who might those be?
Sergeant Matthews. And the victim. Based on some of Sergeant.
All right. Let me call your next witness. Check.
People call Sergeant Mike Matthews.
Be bringing, come forward and be sworn. They bring, yeah. Okay, so they've got to go down and get them. Right. Okay, all right, go ahead.
All right, you solemnly swear in front of the testimony you're about to give to be the truth and all truth and nothing but the truth, so help you God.
I did.
See, thanks for your first and last name for the record, please.
Michael Matthews, Michael, last name is Matthews.
You may inquire.
Thanks, Your Honor. Sergeant Matthews, could you please tell the court where you work?
I work for the University of Michigan Police Department.
And what is your position there?
My current position is a detective sergeant, supervising special victims.
And what are some of the duties and responsibilities you have in that position?
Investigate cases that come in that are of an interpersonal violence nature, and also supervise 1 to 2 officers with their casework.
Were you working in the same capacity in May of 2025?
I was.
And was your attention at some point directed to a case involving a Jerome Burns?
It was, yes.
Could you please tell the court how that came about?
Sure. So during our Monday morning briefing with other department members with the Criminal Investigations Unit, I was informed of custody interpersonal violence that had taken place over the weekend, with that case being walked through by the on-duty detective, and then obtained the casework that he had started and began to manage that case.
And when you began managing that case, what were the steps you took?
It would have been to review everything for completeness. It would have been to listen to any potential jail calls that were made by the person that's taken into custody, and it would have been to attend any court hearings that were scheduled, and reach out to the survivor.
Thank you. And were you able to reach out to the survivor, the victim in this case?
It did initially reach out and left her a voicemail. Don't believe that was the case.
And did you review jail calls for this case?
I did, yes.
And did you find anything noteworthy on those jail calls?
There were several jail calls made during the time that the defendant, Mr. Burns, was in custody. The calls were made to family members, his mother and father, and also subject identified, I believe, as Luke Decker or Decker Lucas. And those calls, they were of interest.
Okay. And can you please tell the court why they were of interest, starting with the calls to Mr. Burns's parents?
During one of the calls to Mr. Burns Sr., defendant Burns indicated that there was a recording on his phone indicating some sort of evidence that would exonerate him regarding this allegation of CSE.
Did he make any statements to either of his parents regarding Madison? Sure, regarding Madison and this ongoing case. And that,
He indicated that he needed her to tell the truth about the case.
the other call was to, I said, the Lucas Decker.
Right.
And what was of interest in that call?
In that call, he had indicated that as soon as he got out of custody, he would obtain a lifetime PPO against Madison and take their child and move, I believe, out of state. I don't remember, I have the exact quote written down, but I don't know exactly what it is.
Do you have that written down in your report?
Yeah, it's on the back page of my report.
Would it refresh your recollection to review that? Is it right over here?
Should be, yes. The police report.
Your Honor, if I may approach before I do, I'm showing defense counsel the report authored by, yeah, I think he wrote some notes on the back of it. Wait. Is it on the back of Officer Norton's report?
Yes.
Okay. The handwriting? Are you referring to the handwriting?
I am, yeah. I do have the audio too available.
One more, Your Honor. Okay, and what I'm going to approach with is, I believe what's in the report regarding the jail call. Should have a supplement for that. This is a call. And that's written by Sergeant. Yeah. Okay. Turn my approach.
You may.
Sergeant, I want to show counsel and what, of course, you can basically look at is the supplement that you offered regarding the jail call. And please let us know when you're done if that refreshes your recollection. Did that refresh your recollection?
Yes.
Okay. And what were the statements made to Louis Decker?
So in addition to obtaining the personal protection order, Mr. Burns also asked Mr. Decker to coordinate with contacting the bank about his vehicle and having members of the bank repossess the car after this court had given permission for Madison to have that vehicle. Specifically, Mr. Burns indicated location where the vehicle was expected to be. He named La Casa, which is a domestic violence.
Yeah, I'm just gonna object to the nature of this whole narrative that's being offered by the officer, primarily because it's not relevant to the case at hand. I know that it is things that stemmed out of the case after it had been charged, but I understand it was a part of his investigation, but it gets us no closer to meeting the standards that we're here for today.
Your Honor, this is all behavior that was designed to make it difficult for this victim. First of all, it shows the pattern of power and control and coercion that's underlying this whole case. But it also demonstrates the length that this defendant was willing to go to make it as difficult as possible for this victim to come to court and to testify. I'm going to be asking more questions about what happened here in court that led to this court's order for that vehicle to be turned over. So we'll get to all of that, and I can ask those questions now if that helps defense counsel see the relevance. But certainly bond violations of bonds, violations of court orders, making it more difficult for victims or witnesses to appear are all very relevant.
Overrule the objection, I'll allow.
Please proceed.
So during that phone call to Mr. Decker, Mr. Burns indicated the location that the vehicle would be at. He's provided Mr. Decker with the name of his bank, which was Door Financial, in addition to two people that worked at the bank that he has dealt with before. He indicated that, or was asking Mr. Decker to contact those people, let them know that the vehicle was there after the court had ordered the vehicle to be turned over to Madison, and have the bank come and get that vehicle as Madison was unloading her property at the domestic violence shelter.
Thank you. At some point, did you, based on this court's order or permission, accompany Madison to retrieve some of her property from what had been the residence of Madison and Jerome?
I did, yes.
And when you did that, was defendant's father present?
He was, yes.
Was there anything of concern to you regarding that interaction? Was he there while you were retrieving the items?
He was, yes.
Was there anything of concern to you that happened during the standby?
Initially, during the civil standby, we were accompanied by a Livingston County deputy. That deputy arrived and left shortly thereafter. He inquired as to whether or not it was court order to allow the standby. Once he left, the initial tone was cordial. And I should note this is a second story apartment with a set of steps. With the truck, Mr. Burns' truck had already been parked outside of the residence, and some of the stuff needed for their son had been loaded up into the back of the truck. As Madison was gathering different belongings and piling them at the entryway, I began to assist and move the property downstairs. When I returned, I found that the father, Mr. Madison, Burns Senior, was engaging with Madison about her.
Object, Your Honor, this is going to be hearsay. This isn't even a party that's related to the case at all.
Fair enough, Your Honor. I'll ask it differently. Without going into without going into what was said, did it give you concerns about? I'll come back to that actually, but we'll come back to it. I want to make sure we're doing it the right way. Moving on to this case proceeding. Were you here in this court ready to testify for this exam at a previous date?
Yes.
And at that point, did you learn that there may be information on Mr. Burns's phone that might be relevant to this case?
Yes.
Could you tell the court a little bit about the phone? Where was the phone initially as this case started?
So originally the phone went with Mr. Burns to Washington County Jail, was logged into his property. Early on, and listening to some of the phone calls, there was mention that there was a recording that was obtained. I looked at the property sheet that the officer filled out when they lodged Mr. Burns at the jail, and looking at that property sheet, the phone was the only item listed that could be able to make a recording. So in an effort to preserve that, I wrote a search warrant, which was approved by the Washington County Prosecutor's Office, sworn to by Magistrate Garwood to seize the phone, which I did, and I logged it into our evidence room.
And did you at some point, were you tasked with conducting or getting help conducting an extraction of that phone?
Subsequent to the phone being logged into evidence, I wrote a second search warrant for a forensic download of that phone. And once that search warrant was obtained, following the same process that I outlined previously, I turned the phone over to Detective Cargill, who did a forensic download.
And was that evidence shared with you?
It was.
From Detective Cargill? And did you then share that evidence with the prosecutor's office with the intent of it being shared with the public defender's office?
Yeah.
In fact, did you make 2 copies of the thumb drive, the preliminary report, and make that available to both offices?
I did.
Was there any evidence associated with this case or potentially associated with this case on defendant's phone?
There was.
Was it your understanding as you're going through this process of obtaining the evidence that there might be potentially exculpatory, potentially beneficial information to the client based on his representation or his counsel's representation?
Yes.
I'm going to ask you about some pieces of evidence specifically. Before I do, actually, I'm sorry. If you know, does the victim in this case have more than one phone?
My knowledge is.
And are there separate numbers associated with those 2 phones?
Yes.
Your Honor, if I may approach with People's Proposed Exhibit number 1, I'm showing it to defense counsel, but it has been shared in discovery as well.
So, Your Honor, I know she has not yet been able to lay foundation, but I am going to object primarily to the introduction of anything that was a fruit of the search warrant itself. I know that the detective has testified to the steps that he used or went through to obtain the search warrant. But I believe that we have not heard testimony yet as to what the search warrant would then subsequently allow him to do. I have a search warrant. I have objections to that. So just for the record.
You have objections to what?
To allowing.
First of all, we're talking about the second search.
That's correct, Your Honor. Second search warrant. So I guess I would ask if people just lay a little bit more foundation in regards to at least how we got to this. I understand that it was from the search warrant, but I mean, if we're ready to proceed, I do object to this particular exhibit coming in primarily because the search warrant essentially that was given did not give any.
Excuse me a second.
Sorry,
because I mean, I was following you up until that point, kind of.
Yep.
I don't know what's being attempted to be admitted. So it's a little bit hard for me to place what you're objecting to in context. Is there a way to sort of generally describe what the purported exhibit 1 is?
Would you like me to? Okay. Your Honor, this is a text message, part of a text message string obtained from the defendant's phone.
Got it. Okay. And you're objecting on the grounds that
The search warrant itself that allowed the police to extract this information from my phone it's extremely broad, Your Honor. There were no limitations based on what the magistrate had signed off on giving them permission to search. I was hoping that people would be able to get to that and allow the officer to testify to what he was actually able to extract from the phone, or at least what permission the search warrant allowed him or they offered to him.
Your Honor, I don't have a problem asking more questions. What I'm now concerned with is that there is an objection to the search warrant. There's a claim that the search warrant is not good, essentially, which should have been a motion before this court prior to today. I'm at this stage not prepared in the middle of testimony to argue the validity of the search warrant. So that's not what I'm going to do. I don't have a problem asking more questions. If counsel wants to voir dire on the exhibit, of course, that is her right. However, I'm not going to have a whole hearing on the search warrant at this stage.
So what is your objection to the search warrant? I guess
So essentially, Your Honor, my understanding of the search warrant, the second one that is,
Can I, and before you answer that, I mean, just timing wise, as I'm done, recall and understand, your client makes a statement that on his phone is something exculpatory or something that may clear him or beneficial to him.
Yeah.
Based upon that, I think maybe we can all agree on that. Based upon knowledge of that, University of Michigan Police obtain a search warrant to basically go into the phone. Are we all on the same page?
that's correct.
They obtain certain things. It doesn't, I don't know whether inculpatory or exculpatory. But now you're objecting to the warrant itself.
Your Honor, in reviewing the warrant, the warrant gives permission for a full review with no specific date range being requested, or basically being given an order to police. Our issue with that, Your Honor, is the fact that it's overly broad. It gives them full access to the phone. I understand that the people may have wanted this, or the court may want this in motion form. That's something that we absolutely can do. However, just in reviewing the search warrant itself, there just are no parameters to it. It gives them free.
So because of that, you'd be objecting to the admission or even questioning regarding proposed exhibit 1.
That is correct, Your Honor. And I mean, that's correct, yes. And I think that objection would subsequently stand for any other exhibits that pertain to the extraction of the phone. And I just want to bring it to the court's attention in regards to timing. There was just a recent case that was brought to, that I found out about that gave rise to questions, People versus Carson. It gave rise to questions about validity of search warrants and the level of unconstitutionality. This is a case that was just decided on July the 31st. So it's a very new case. I know that again, and just preparing for
is that I haven't seen that case, but I guess is that something in specific to the narrowness of the search of an electronic device? Is that
that's what the case speaks about?
Your Honor.
Yes.
Sorry, may I?
You may.
Your Honor, other than my initial problem with objecting to the search warrant at this stage. That objection stands. We have a situation where, and we just went over this morning, where the defendant is claiming without any specificity whatsoever that there is exculpatory evidence on his phone. We have asked for specificity multiple times. Had there been specificity in his statement, perhaps the search warrant would have contained some specificity. When we are told that his phone has exculpatory evidence with nothing more to go on, and are essentially tasked with going on a fishing expedition and exploring this entire phone, and in addition to that, he will not give consent, which is his right. He will not give consent, despite many conversations, for us to get that potential exculpatory information. The only thing we can do at that point, so that we are doing our jobs, so that we are protecting his rights, so that we are not violating the law and the Constitution, is to get a search warrant to go into the phone to see if there's exculpatory evidence. We have done our best. Law enforcement has gone above and beyond trying to find this supposed exculpatory information. What I was about to present was a text message that is potentially exculpatory, that has been shared with defense, that the defendant is well aware of because it's in his phone. And now there are problems with the search warrant being too broad. There's been conversations about needing to review the entire contents of the phone, but now there's a problem with the search warrant being for the contents of the phone. Your Honor, I'll leave it to you. I don't know what else to do at this point.
Well, I was just about to say, because I can really, and I understand, I guess, the difficulty of the circumstance, but we spent this morning, well, the latter part of the last hearing, and it seems every time we come here, arguing over something that the defendant claims to exist on this phone. He doesn't consent to the phone. They get a search warrant to find what he says is evidence favorable to him. Now, the danger in that is that when they go and do this, there may be found things that are not favorable to him. If I just make the presumption, and again, I haven't read the text message, but let's say it's something that is not favorable to him, then I not only am getting an objection to that text message, but I'm then getting an objection to the search warrant. And I guess in essence, the whole process which led to the search warrant and the discovery of this proposed Exhibit 1. And so I have to say I'm a bit baffled by that. I'm a little bit concerned that it was a recent case, Carson, and how you're saying that case, but I believe there were a couple of previous cases that basically argued the narrowness of a search warrant regarding an electronic device, that you just don't go carte blanche.
That is correct, Your Honor. From my review of the case, it does speak about the narrowness of the search warrant, especially when it comes to electronic devices, essentially indicating that people's entire lives are on their electronic devices. Obviously, the outcome for Mr. Carson in the case was not, he didn't get the decision that he was looking for. However, and specifically, he was asking for a new trial. He was not given the new trial, but the Supreme Court did have a lot to say about where we stand right now in regards to search warrants. And again, this is a case that it's a hefty case, and it's still working through it. But
Your Honor, I am familiar with Carson. Our office actually has taken very, very detailed measures to make sure that our reviews of search warrants are run by our appeals department. We've had trainings. I'm aware of all of that. However, those situations are very different, because if we were to go and take defendant's phone looking for evidence that is inculpatory of this crime, then yes, we would absolutely have to narrow it down. We'd have to follow all, and it's not just Carson. I mean, there's a long history of what search warrants are supposed to look like and what they're not supposed to look like. That is not the situation. And in fact, it was actually defense's argument this morning that this situation is unique. So you can't have it both ways, and that's where we are. And I understand this defendant wants everything to be speedy, but he also doesn't want us to be able to use the evidence. When he is insisting on us proceeding today and claims that he is ready to go, the expectation cannot then be that you're all of a sudden out of the blue going to claim that the search warrant is invalid. That's just not how things are done. We cannot start this. We cannot be ready to proceed to then have a problem with the search warrant and tie our hands so we can't use any of the evidence.
Well, and that was one of the things I was going to say, that, and maybe Miss you can, because I have not read recently, like Carson. I've gotten a synopsis of it. So I mean, I understand the concept, but is there something in that case that would make it applicable to a circumstance such as this, as opposed to a circumstance where the police, through an investigation or otherwise, seize a defendant's phone, looking at it initially for items of evidentiary value to their case?
And Your Honor, I will say that that is the difference in our case, right? In Carson, his phone was seized as a part of it was seized, he was subsequently arrested, and that was a part of the evidence or investigation that the police did in that matter.
Right, and would you agree that that makes this that's a big distinction between what Carson was getting at in terms of the narrowness of what one is looking for, as opposed to this circumstance that we have in this case? And I'll be honest with you, I'm a little bit baffled because earlier this morning, what we were talking about was that there was a request by the defense for the full download that the police obtained. And we went through that. I took a break so that you could talk to the client about the implications of that and where he wanted to go with the case. And now while I want it, now I'm objecting to the fact that the police haven't did that.
And that's correct, Your Honor. I mean, well, not that's correct, but yes.
Well, no, it's correct what I just said. You just don't like the way I said it, maybe, but it's correct.
That is fair.
Okay.
And Your Honor, if the court does allow this, I mean, we still obviously stand on our position that we want or needed or would like the entire download if it's in their possession and they have it. But I would just be remiss if I did not bring it to the court's attention, how we believe that this case relates to our case.
Your Honor, I hate to do this. Could we approach briefly?
Oh, no, that's what happened with you too. Whenever that happens, trouble happens. Come on.
5B 148931 A, B, and C. I don't have a problem with their adjournment, but I want to make sure that this appears to be, well, no, it isn't. Calling the prosecutor, Jonathan Patrick Johnson. 25B148932, 25B148931A, B, and C. So he wanted an adjournment because he couldn't get a ride?
That is correct. And I did notify him that any other court date would be a Wednesday morning and he had to find a ride.
He's got a prior.
He does not.
I'll give him this adjournment, Lisa. Tell me must appear. If he contacts you and he says that again, I don't have a problem with Zoom. She's got his number on here. I need not repeat it now. Maybe you can call him and say, hey, we're going to reschedule this. But he's got a prior just a year ago. And if he absolutely can't make it, I'll let you be the judge of that. Then you can set by Zoom, okay?
Okay.
But he's got several files here. I think that's the best way to play it. So I'll give him the benefit of the doubt on this instance. Thanks.
Thank you.
Is anybody ready to go on? Okay. Mr. Teo probably has these from Mexico. Kelsey Marie Marble. Okay. She didn't show up. This is 25A148-571. Prosecutor requested default entered. It was scheduled for 8:30. So I'm going to enter a default judgment. Defendant failed to appear. It's now 9:13. Officer is on text standby. Complainant is here in person. Who was the complainant? Okay, so you're free to go. I'm going to enter a default. So you. Okay. Thank you very much. Marcel LeQuinn Cole, 25B148662A and B.
Right to the podium. Yes, sir.
Okay, come on up here. Your name?
Marcel Cole.
You're charged with driving on a suspended and no proof of insurance. You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer? You want a lawyer?
Courtroom.
Yeah, we'll give you a lawyer right now, okay? Can you go out in the hall and then they will, they'll meet with you and either way you're coming back in front of me, okay?
Thank you, sir.
You're welcome. Michael Anthony Franklin, 25B149184A and B. Your name, sir?
Mike Franklin, good morning, Your Honor.
Good morning to you. You're charged with driving on a suspended and using a handheld device while operating a motor vehicle. You have the right to a lawyer. Do you want one?
Yes, sir.
Okay, we'll set you up with a lawyer. Either way, you're coming back in front of me, okay?
Thank you, sir.
You're welcome. Are you ready on Mexicot?
Yes, Judge.
Tyler Mexicot, Tyler James Mexicot, 25B148704B.
Deanna Rizzi on behalf of Mr. Mexicott, Fleischer, for making the order.
Tyler James, Mexicott.
Good morning, Ms. Patillo and Mr. Mexicott. You're here for sentencing. You pled guilty previously under 7411 to the charge of possession of a controlled substance. I referred you for a screening and assessment. He's got warrants all over the place.
So yes, Judge, I did discuss that with Mr. Mexicott. He understands that he will have to take care of those warrants before the conclusion of the probation.
Well, he's gonna do it quicker than that. Mr. Mexicott, you and I are not gonna get along if you don't show up in court like this.
There was a stretch of time where I was not doing well, and I'm here to.
Okay. All right, well, we'll take care of this now. So he pled, it's under 7411. Have you reviewed the report, and are there any material additions, corrections, or deletions?
Only one correction, Your Honor. So on the second page, it says there was a reported history of blackouts. I guess he was confused by the questionnaire. He doesn't have a history of blackouts.
Okay.
So he just asked if that could be stricken from the report.
All right.
Other than that, there are no.
I'll modify the report in that aspect. What else?
There's no other additions, deletions, or corrections for the report, Judge.
And he's still seeing the therapist, are you, with the community care?
Yes.
And that's a substance abuse treatment specialist, right?
Yes, Your Honor. I have a social worker and I see a psychiatrist, and I have an old group of people there that help me.
How often do you go for substance abuse treatment?
About 3 times a month, and then I also do it on my phone. I've been on Suboxone for like 6 years, almost. And I do drug screening for all of that.
He's also.
But you were on cocaine until recently, and then you had all these drugs in your car.
That's not correct. I wasn't in a motor vehicle, and.
Wait a minute. Well, you hang on a second. Let me just read to you what I read here. All right. You were at Burger King. This is according to the report. You were trying to sell drugs. I'm just telling you what they said. Caller advised dispatch the male was trying to sell the employees drugs. He began punching the building in the drive-thru. Was leaving south on Telegraph. White male with a black shirt and black pack. He ordered you to stop, and you threw a backpack and other items into the grass. That's what this report says. That's when they saw a black revolver. And then when they took all those narcotics, you had multiple suspected Xanax pills, two knives longer than 3 inches, a pistol, suspected bud of marijuana and folded up piece of paper, and he's aware, this is what the officer's writing, I'm aware that folded up pieces of paper are referred to as bindles and are used to contain and transport loose narcotics such as cocaine, fentanyl, crystal meth, and heroin. He identified the item as a bindle and observed a white powder residue inside the clear Tupperware container. So I'm a little confused when you're telling me you haven't used in that many years.
I didn't make it home to do the drugs, Your Honor.
So you had them.
And
you were clean for 6 years, you're trying to tell me.
Yes.
Except for the cocaine 2 years ago. Then all of a sudden on this night, you decided to go and start using?
I don't know where you're getting the cocaine from 2 years ago, Your Honor.
Okay, let me just read this here. Reports previously used heroin, other narcotics, crack, and amphetamines, but it's not used in 6 years. Reports a history of cocaine use. reports has not used in 2 years. I'm reading that as saying you were done with these other drugs in six years ago, and you used cocaine until 2 years ago. If I'm misreading it, you can tell me. But either way, here's listen. No matter if it was 2 years ago, 2 weeks ago, or 2 days ago. The fact is that only a month ago, July the 11th, you had drugs on you. And now, from what you're telling me, I hadn't used in a long time, but I had these drugs and I was going to go home and use them. Am I understanding correctly, or is that wrong? So just out of the blue, after not using any of these drugs for 6 years or cocaine for 2 years, however you want to read it, you just went out and started buying, going over to Burger King and trying to sell drugs. Am I right? Look, I'm asking you a question now. You don't need to talk to your lawyer about this. I want to know the answer. You are too young to be using drugs like this. You are going to die before you hit 35. Now, I can help you, or you can play this little game and act like, hey, I'm a choir boy, and I'm going to be an altar boy too, and I'm going to sing in the choir on Sundays, and then you're going to be dead in 3-4 years. You're 31, right?
That's right.
Okay. So you do what you want.
I did start going to meetings already, like requested.
Are you listening to what I just said? I want you to answer my question. I want to make sure I understand the scenario. You hadn't used anything in 2 years, and on this day, you just decided you wanted to go acquire drugs and handguns and go into a Burger King and try to sell the drugs. According to them, tell me. I want to know. Is that what you're telling me? I'm not trying to trick you.
I didn't go inside Burger King. Burger King was closed.
Well, you were going through the drive-through, right? You were trying to sell from the drive-through? I mean, forgive me if is that right or wrong? Is that what you were doing? Were you trying to sell drugs there? I'm getting frustrated with you, Mr. Mexican. Just tell me the truth.
No, that's not what I was doing.
Are you going there to buy food?
No.
And what were you doing at Burger King if you're not there to sell drugs and not there to buy food? Why would you go to Burger King?
To leave my house.
To what?
Just to get out of my house. I don't really have a house.
Do you live on Seminole Lane?
That's my mailing address, but I don't.
Are you homeless?
Yes, you are.
Who lives on Seminole Lane?
My fiance's father.
You graduated from high school and you got some college, right? Why aren't you working more?
He is employed, Judge.
I know. He's making $400 a week. He's still collecting bridge. What's that?
I just got a second job that I started on Monday.
Where?
At Little Caesars in South Bay.
How many hours are you going to work there?
They said it would be full time between two different locations.
Okay. And are you still going to work at the car wash?
Yeah.
How many hours a week there?
It's roughly 30 to 40.
All right. I'm not trying to quarrel with you. I'm trying to figure out what I can do. I'm not sure he shouldn't get in sobriety court, to tell you the truth.
So, Your Honor, the only thing with Mr. Mexicott doesn't have a car. He doesn't even know how he's gonna get home or back to the hotel from court.
Who's this with him? That's his what, girlfriend, fiance?
to my,
Does she have a car?
no, Your Honor.
Did she walk here?
No, Your Honor.
They were dropped off by a friend, Judge. So he is doing things in terms of sobriety. He has a Suboxone doctor that he tests.
That's gonna help with the opiates, I get it.
And he tests with them 3 times per month. He tests 3 times per month also with community care. He also goes to meeting with Serenity and Southgate 3 times per week. So he's trying.
Okay.
And the job, one of them that he has, he's able to walk. It's 5 minutes from the hotel, Your Honor.
How's he gonna pay for his testing? I can't just accept results from community care or these other locations. I wanna be clear about that. So he's gonna have to get his act together. I'm gonna put you on probation. Have I let you finish? Is there anything else you'd like to tell me? 16 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. I will take this under 7411. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. I should probably order bi-weekly testing or twice weekly testing. I'm going to order weekly testing for 3 months. If you're clean, I'll then make it bi-weekly for 3. So you're going to test weekly for 3 months. If you're clean, I'll make it bi-weekly for 3, then monthly. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I want you to go to an intensive outpatient treatment program with aftercare. Doesn't sound like what you're doing complies with that. Going 3 times a month is not intensive outpatient. You need to go to intensive outpatient. AA in addition, twice a week. We're gonna hand you a form every time you go. You have to have the form signed. That has to be in person, okay? You're going in person AA, right? All right. I won't make you do court work. I'm gonna make you do community service. I'm gonna give you all the way until October the 25th to complete that. You need to get your life back in order here. Fines 100, cost 225, 75 victims' rights fee, $50 justice assessment. That's $450. Screening fee 60 for 510. Probation fees are $320 for a total of $830. I won't even charge attorney fees on this. I'm going to give you a review hearing date. All warrants to be cleared. I'll give you a little extra time than I usually do. I'll give you until October 15th to clear all of your warrants. I'll let you pay this at the rate of $40. I'm going to say $40 bi-weekly, and I won't start that until October the 10th. Okay? If you ever need more time, you come and talk to me. I'll be happy to give you an extension, or you can call the court. We'll go on Zoom. Lisa, give me your review hearing date, please. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that?
Yes, sir.
December 2nd of 26 at 9 o'clock.
I'm sorry, what day?
December 2nd of 26.
So 12/2 of 26 at 9 a.m. will be your review hearing date. We're going to give you a notice. If you're compliant, the case will be dismissed at that time. If you get through this in half the time, the prosecutor will most likely, on your motion, move to dismiss early if you're clean. And you do everything I told you to do. Do you understand that?
Yes, Your Honor.
You'd have to have everything taken care of, though, community service, fines, costs, etc. But you've got 8 months. You got to get your life in order, son.
I'm gonna have a baby in December. I know.
Well, congratulations. Very good. Do you know if it's a boy or girl? Good. So it's the most important thing you're going to do in your life is be a parent. Good luck. I wish you well. Go down, get your notice, meet with probation. They'll go over the order with you further. Thank you.
Thank you.
Devontae Varstelis Smiley, 25B 718-164. Good morning. Your name?
Good morning, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
Boy, I'm getting more signing on records, I think. Raise your right hand. You solemnly swear to affirm under penalties of perjury the testimony you'll give in these proceedings will be the whole true self you got.
I do.
Okay, go ahead.
Your Honor, on December 27th of 2024 at approximately 5:35 a.m., Officer Cormier was on routine patrol on Sibley Road west of Beach Daily Road when he observed a white Jeep Grand Cherokee traveling at what appeared to be in excess of the posted speed limit of 45 miles per hour. After the Jeep passed Officer Cormier, it turned northbound onto Beach Daily, and Officer Cormier observed that the taillights of the Jeep were defective. Officer Cormier proceeded to turn around on Sibley Road and followed the Jeep onto northbound Beach Daily Road. However, by the time Officer Cormier reached Beach Daily Road, he could no longer see the Jeep. Officer Cormier continued northbound on Beach Daily Road to Pennsylvania Road, where he observed that the Jeep had been involved in a serious crash in the intersection. Officer Cormier reported the crash to dispatch, and several additional Brownstown officers, the Taylor Fire Department, and the Downriver Crash Team all responded to assist with the crash investigation, as the drivers of both vehicles claimed injuries and were transported to Corwell Hospital in Trenton, Michigan. Officer Paul of the Downriver Crash Team led the investigation. During his investigation, Officer Paul determined that there were two vehicles involved in the crash: a white Jeep Grand Cherokee, Ohio plate JYT 3524, driven by Devonta Varselis Smiley, and a black Ford Escape, Michigan plate Edward Henry Boy 3240, driven by Emily Lynn Haddox, and that the crash had occurred in the intersection of Beach Daily Road and Pennsylvania Road. At the time of the crash, the traffic signal was flashing yellow for eastbound and westbound Pennsylvania Road traffic and flashing red for northbound and southbound Beach Daily Road traffic. Officer Paul determined that Ms. Haddox was eastbound Pennsylvania Road with the flashing yellow light, and that Mr. Smiley was northbound Beach Daily Road with the flashing red light. Mr. Smiley failed to stop at the traffic signal before proceeding through the flashing red and crashed into Ms. Haddox's vehicle. Both vehicles suffered severe disabling damages and were impounded and towed by Martin's Towing to their impound lot. During the inventory search of the vehicles, Officer Paul and Officer Waterworth discovered an unregistered handgun on the front driver's side floorboard of Mr. Smiley's vehicle, and an open bottle labeled promethazine with codeine oral solution on the floorboard behind the passenger seat of Mr. Smiley's vehicle. The female renter of Mr. Smiley's vehicle, the Jeep out of Ohio, was not present at the time of the crash and contacted dispatch to claim that the firearm found in the vehicle belonged to her and had been locked in the glove box prior to the crash. Both the firearm and the oral solution were seized as evidence. After being transported to the hospital, it was determined that Ms. Haddock suffered a closed displaced fracture of her left clavicle, which required surgical intervention, and an interparenchymal hemorrhage of her brain. While on scene in the rear of the ambulance and again at Corwell Hospital, Mr. Smiley admitted to Officer Mott and Officer Waterworth that he was the driver of the Jeep at the time of the crash, and informed Officer Mott that he was traveling at a high rate of speed to avoid receiving another ticket that night. Based on the investigation, Downriver Crash Team member Officer Mott subsequently sought and obtained search warrants for the crash data recorders for both vehicles, which were approved by the prosecuting attorney, Mr. Kazak, and authorized by the Honorable Judge Coleman Hessen of the 33rd District Court. Subsequently, the Downriver Crash Team members, Officer Paul, Officer Mott, and Southgate Police Lieutenant Lukovsky, went to Martin's Towing with the search warrant to inspect the crash vehicles and download the CDR data. Following the download, it was determined that the CDR data showed that Mr. Smiley was traveling at 115 miles per hour in an unmarked 55 mile per hour zone 5 seconds before the crash occurred, and that he had slowed to 75 miles per hour at the time of impact with Ms. Haddox's vehicle. It also showed that Ms. Haddox was traveling at 45 miles an hour in the posted 45 miles per hour zone at the time of the impact. Based on the crash investigation and CDR information, Officer Paul determined that Mr. Smiley had operated the Jeep Grand Cherokee in a reckless manner by driving at more than twice the posted speed limit prior to impact, and that Mr. Smiley disregarded the traffic control signal by failing to stop at the flashing red light at the intersection. Officer Paul further determined that Mr. Smiley's actions were the direct result of the injuries sustained in the crash to Ms. Haddox. I was subsequently assigned to provide additional investigatory services for this case. I performed a lean CCH check for Mr. Smiley, which showed he was a convicted felon currently on probation for a felony offense who should not have had a firearm in his possession. The passenger in his vehicle at the time, Mr. Matthews, was also a convicted felon. Based on this information, I sent the unregistered Glock 43X to the MSP Crime Lab for NIBIN testing and also contacted ATF Special Agent Madison to request a trace of the unregistered firearm. The results of that trace did show that the handgun was purchased by Mr. Smiley's girlfriend, a Miss Tatiana Garcia. Additionally, I sent the plastic bottle containing the red solution labeled promethazine with codeine to the Michigan State Police Crime Laboratory in Detroit for testing. MSP forensic scientist Ms. Gerlowski determined that the substance in the bottle was not promethazine with codeine, but it was instead heroin, a Schedule I substance, and that the weight of the bottle recorded after analysis was 253.94 grams. After obtaining the results from the laboratory, I spoke to Officer Paul regarding the cell phone seized during this incident, of which there were 3. Officer Paul indicated that following the seizures of the phone, one of the phones was blowing up with messages while it was awaiting processing. Officer Paul stated that based on his training and experiences, the messages appeared to be associated with illegal narcotics activity. I subsequently obtained a search warrant for the two seized cell phones that were still operational, Mr. Smiley's black iPhone 14 Pro Max and Mr. Matthews' white iPhone 14 Pro, to uncover evidence related to this incident and possible narcotics distribution related to the recovered heroin. My search of the phones revealed that both Mr. Smiley and Mr. Matthews appeared to have been involved in narcotics distribution throughout the Wayne County area. Mr. Smiley even told Mr. Matthews in one text message that he had, quote, codeine, which at the time of this incident, he possessed promethazine with codeine oral solution, which, as aforementioned, turned out to be heroin. A subsequent lean CCH check for Mr. Smiley revealed that he has 1 prior felony conviction for which he is currently still on probation. And the date of that offense is May 10th of 2024 out of the 3rd Circuit Court in Wayne County, where he pled guilty to felony attempt controlled substance delivery manufacture methamphetamine.
All right. Based on your sworn testimony, I find that the crimes, possession with intent to deliver more than 50 but less than 450 grams of heroin was committed. There's probable cause to believe the crime was committed by the defendant. Also that he committed the crime of CCW, reckless driving causing serious impairment, and then felon, in possession of a firearm by one who was ineligible to do so, and also that the defendant has the prior convictions as set forth in the habitual second offense notice. So I'm going to authorize the issuance of the complaint, finding probable cause. You signed it, I've signed it, and I've signed the warrant. You're all set. Thank you.
Thank you, Your Honor. Have a good day.
You too. Priority Logistics 1 LLC, 25B149093. Good morning. Mr. Dillon, good morning, your appearance.
Good morning, Your Honor. Alex Dillon on behalf of Priority Logistics.
All right, so you met with the prosecutor, talked to them. They're going to agree to, you're going to plead to overweight, agreed upon fines and costs of $3,400, correct?
Correct, Your Honor.
And you're authorized to enter this plea, correct?
Yes, I am.
To that charge of overweight, responsible or not responsible?
Responsible.
Please accepted. Fines cost $3,400, paid by September 13th, okay?
Thank you very much, Judge. Appreciate it.
Okay, thanks.
You do the same.
Do I have Red Wing Transportation? 25B148871. Are you from Red Wing Transport? Is that why you got the red shirt on? I'm just kidding. Come on up here. Tell me your name.
Gerald Selman.
You got to go to the podium there. What's your position with Red Wing Transportation? You have to at least be the president, or I can't take this plea.
I am.
Okay. I'm going to bend this ever so slightly, since there's no, typically corporations. Is this a corporation?
Used to be. Hasn't been in about 10 years.
What is it, an assumed name now?
Yes.
Okay. Well, then I can definitely, is it your name doing business as Red Wing Corporate Transportation?
Yes.
All right, good enough. You're going to plead to impeding, right?
Yes, sir.
Responsible or not responsible?
Responsible.
Lisa, right now, we should have, correct me, a default judgment entered on this. Is that true or false?
Let me check. No, we don't.
Okay. I saw that on July 17th, I wrote down default judgment, but then they never received notice according to this. So
They showed up later. Yeah, we had to reschedule and they didn't get the new notice.
good enough. You're going to plead to impeding traffic on behalf of your company, and the safety equipment charge will be dismissed. True?
True.
To that charge of impeding traffic, impeding traffic, responsible or not responsible?
Responsible.
You got to take it out of the building, sir. We got signs all over. I'm sorry.
3 signs on the way, 4 signs.
I'll accept the plea, 235. Can you pay that today?
I didn't bring a check. Could I have a week?
Safety equipment charge is dismissed. Where's your company at? Detroit?
Yes.
You can go online and pay this, you know.
Okay.
33court.com. So can you pay that now by the end of the day?
Yes.
All right, 4 p.m. today, okay?
Yes, sir.
Good luck to you. And if you need any instruction about how to do that, they'll give it to you down the hall, all right?
Okay.
Alicia K. Hamilton, 24W834317. Did you have a lawyer today, ma'am?
Yes.
Who's your?
She was in here just a few minutes ago.
Okay, have a seat right behind you. As soon as she comes back in, I'm going to take this. Did we call Rockwood on this?
I don't even know what teacher is called.
Charlie Taylor.
Yeah, they're here.
Okay, bring them in. People against Charlie Daniel Taylor, 25R718732. I haven't done the signing on record yet, I don't believe. So, Mr. Barry, you and your client can just have a seat right there and I did do that. I did do that the other day. My apologies. Come on up to the podium, state your name.
Thank you, Judge. Lieutenant Ricker called us.
Okay, good enough. Your appearance?
Ryan Berry, appearing on behalf of Charlie Taylor here on your.
Sir, your name?
Charlie Taylor.
And Lieutenant, your name?
Active Lieutenant Steve Mercury, Rockwood Police.
All right, so what do we have here? We have a charge of OWI 3. Does he stand mute? Wait for him reading?
Correct, Your Honor.
All right, so I'm going to go ahead and advise you of your rights, sir. You have the right, you're charged with this felony, and you have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes, Your Honor.
You have the right to be represented by your lawyer not only today, but at all subsequent court proceedings. Also, if you choose to submit to questioning at any time with law enforcement officials, you have the right to be represented by your lawyer at that questioning. Do you understand that?
Yes, Your Honor.
You have the right to a probable cause conference within 14 days. I think somebody gave us the wrong dates, didn't they? Probable cause conference, they got set for the 19th. Is that what they wanted to do, Lisa?
No, that should be the 26th and the 2nd.
Right, okay. I just wanted to double check. All right. So you have that right to a probable cause conference within 14 days. You have the right to a preliminary exam within 7 days thereafter. At the preliminary exam, the people have to show that the crime was committed and that you were the one who probably committed the crime. If they prove that, you need some weight on. You'll be bound over for further proceedings to the Wayne County Circuit Court. If you fail to prove that, that charge would be dismissed. Do you understand that?
Yes, Your Honor.
Give me 1 second. So August 26th at 10:30, Mr. Berry, that's in front of Judge Hessen. And then you'll be back in front of her if it goes to the exam on 9/2, right? 9/2/25.
Yeah, September 2nd at 10:30.
I'm sorry. Say that again?
Would be, the exam date would be September 2nd at 9:30, 10:30, sorry.
Okay. At 10:30. So both days you're gonna be in here at 10:30. All right, now, so I'll listen to you address bond. Anything you'd like to say?
Thank you, Your Honor. This incident allegedly happened on the 12th of July. On the 14th, Mr. Taylor got himself into AA, has done about 18 meetings so far. He does have a sponsor. His sponsor is Stan Willis. He has no other criminal charges other than the prior two for the OWI. He's been a Flat Rock citizen his whole life, and he owns his own business. So he is gainfully employed. He is the sole provider for his family. As soon as we found out, he retained me even prior to the charges being issued. We've been in contact with the police department, and Lieutenant Burker was kind enough to call us and let us know that it was sworn in on. We appeared right away.
All right, how much money does he make in his employment?
I do contract work, so it varies by month and by job.
Roughly, what did you make in 2024?
Brought home about 76,000.
Okay. Lieutenant, you have to remind me, he had the prior in 06 and 22. Can you just tell me what his blood result was on this case?
The blood was a .19.
And was there an accident?
No, Your Honor.
What do you have to say regarding bond?
Mr. Berry called me before the charges were even brought about. I called him. He turned himself in. I'm not opposed to a personal.
All right. So here's what I'm going to do. I'll give you a $10,000 personal bond. But here are your conditions now. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. I want you going to AANA at least 4 times per week, and you do have to be on a sober length device. You have to acquire one and blow into that machine 5 times a day. They'll explain everything to you by the end of the day. So you can go over to probation. They will instruct you as to where you have to go to acquire that, and you have to be on that by the end of the day. No contact with prosecution witnesses. Has he already been printed and photographed on this? Yes.
Yes, he has.
Okay. All right.
Would you have any objection if I had him set up through Nationwide?
I don't care who does it.
And just give him till tomorrow by, let's say, 1 o'clock. It's in Troy. I'll try to get him hooked up today.
Well, I don't have a problem. You go talk to probation. I can't imagine a problem with Nationwide.
Okay.
That's what we use on our interlock, but I want him to do it by the end of the day, unless he's got to work today.
Okay.
Okay?
Okay, thank you, Judge.
All right, no problem. But do run that over by probation if you would,
And
okay?
I'm assuming you wouldn't have any, I think SoberLink is probably the way to go, but if you wanted to do the bracelet, you would.
I don't have a problem with that, but it's more expensive.
Okay,
You talk about the alcohol tether?
yeah.
Yeah, it's just more
I
expensive.
mean, I don't, just,
And then I hear about environmental factors.
okay.
You know what I'm saying? Not very often, but now and then somebody's going to tell me that, well, they were positive because of whatever. So I'd prefer a sober link.
Thank you, Judge.
Okay, have a good day. Thanks.
Thanks, Lieutenant.
Thanks, Lieutenant. STS Contractors LLC. 25B 148660. Your name? What's your name?
I'm Sean Miller.
You're the owner of the company?
Yes.
Why didn't you show up before?
I came, I didn't get the other, I came here, but I came at 1:30 was my paper head.
All right, you're going to plead on behalf of the company. Are you the president?
Yes.
And I'm sorry, spell your name again, last name?
SEAN and Miller, MILLER.
All right, so you're the president of STS. You met with the prosecutor, and you're going to plead responsible to overweight with agreed upon fines and costs of $2,000. True?
Yes.
To that charge of overweight, responsible or not responsible?
Could you say that?
Do you plead responsible or not responsible to overweight violation?
Responsible.
Okay, I'm gonna accept the plea, $2,000. How much of that can you pay today? Anything?
Probably maybe $200.
When can you pay this?
I can pay that today.
No, I know, but when can you pay the 2,000?
I told her I need some time to pay.
Well, tell me, talk to me.
Oh, at least 6 months.
6 months?
Yes, I'm not making, like I told her, I'm not making money like everybody. You know, I came through there, I told her that day, it was the first time I
Look, I can do this for you. I can have you pay $200 a week.
200 a week?
I'll do that for you. I can't do much better than that. That's 2.5 months.
Okay.
Do you think you can handle that?
Yeah, I can handle that.
You sure?
Yeah.
All right. So $200 today. $200 due each week. And I'll tell you what, I'll give you a little leeway time. So I won't start that payment plan until August the 25th. Is that okay?
Yes.
Now, if you don't have the money, there's no worries. You call the court, we'll go on Zoom on or before any one of your due dates.
Yeah.
Or you come and talk to me on or before any one of your due dates. I don't care if we have to do that 83 times. I'll be happy to give you an extension. Just don't ignore me or I'm going to get cantankerous, all right? I can't stand that. When I offer that to people and then they don't show up and don't pay, then I'm not going to be so nice. That's fair, right? Okay, good luck. Thank you. You're welcome. Do I have anything else ready that doesn't have a lawyer here? Who's got Heather Ann Dragosh? Did she have a lawyer?
No, I do not.
Okay, you're representing yourself. You can come on up here. People against Heather Ann Dragosh, 25BA269OA. Good morning. Your name?
Heather Drogash.
All right. So you're going to plead no contest
Yes, sir.
to vicious act under section 771.1, right?
Yes.
And do you understand a no contest plea has the same effect as a guilty plea? Do you understand you plead no contest that the possible penalties on this are up to 500 fines, 90 days jail, costs of all those? Do you understand that?
Yes.
And did you sign an advice of rights form here today?
Yes, sir.
Did you read it and understand it?
Yes, sir.
If you plead no contest, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that?
Yes, sir.
And you understand, according to the terms of the agreement, if you're compliant after I accept your plea and sentence you at the end of 12 months, the case will be dismissed on motion to prosecutor. Do you understand that?
Yes, sir.
All right. Do you have any objection? Now, just so you know, when I take a plea, I have to ask questions that establish a factual basis. My presumption here is that you're pleading no contest because there's a possibility of civil litigation, in which case a no contest plea is appropriate. But I still need to make sure in my mind that you're guilty. And since I'm not going to ask you questions, I'm going to have to do it reading the report. Any objection to my utilizing the police report to establish that you're guilty?
No.
All right. So I'm going to have that marked Peoples 1. Do you understand everything that's going on here?
Yes.
All right. To the charge of animal vicious act, how do you plead?
No.
All right, I'm going to review the report. I've had it marked Peoples 1. Was this dog given rabies shots before the incident date?
Yes. She was renewed for her second year.
All right. Are you on probation or parole?
No, sir.
And has anybody forced you to plead no contest?
No, sir.
Okay, so I'm going to accept your plea I'm still gonna set a sentence date. We have to still notify the victim of the right to appear here, okay? So I won't need a pre-sentence report, Lisa. So we need to make sure that the victim is notified, and I will give you a sentence date now, at which time you'll return for sentencing, okay? What do you have for me, Lisa?
August 27th at 8:30.
So August 27th at 8:30, you can go down the hall and get your paper notice. The bond is continued, so the dog has to still, again, remain in the fenced-in yard or your home or on a leash and equipped with a muzzle accompanied by you or another suitable adult. Also, no contact with the victim or prosecution witnesses. Do you understand all those terms?
Yes, sir.
Do you have any questions?
No.
All right, you're all set. We'll see you back here on that date. And by the way, let me just double check one thing. Yeah, I should have said, and I didn't say, the B and C files, dog at large and no dog license, are dismissed pursuant to the stipulation. Okay? So those two cases are dismissed. Good luck. We'll see you back here in a couple of weeks. Thank you. McLaughlin, Ariana Anne-Marie McLaughlin, 25B1491798 and B. Good morning. Your name?
Ariana.
All right, so you're charged with driving on a suspended and speeding. You have the right to a lawyer if you want one. Do you want a lawyer?
No.
Okay, I'll arraign. I'll explain the charge and possible penalties, and then I'll send you to the prosecutor and you can talk to her. And if they don't give you what you want, you can come back in here and tell me you want a lawyer. Fair?
Okay.
On July 21 and 25, the police think you were operating a motor vehicle in the township of Brownstown on Dix, Toledo, near Pennsylvania at 1:17 p.m. That is a misdemeanor punishable by up to $500 in fines, driving on a suspended. These are just the maximums, so don't get all panicky. 500 fines, 93 days jail, costs are all those. 2 points will be added to your traffic record. There's also a speeding violation of 5 over, which if you're convicted of that, and that's a civil infraction, that's 1 point. Although if you're convicted of both things here, you only get the higher of the 2 point total. So you can get 2, not 3. Does that make sense?
Yeah.
All right. Did you sign the advice of rights?
Yes.
Did you read it and understand it?
I read it. Understand.
If you plead guilty at any time, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes.
All right. You still wish to waive your right to a lawyer?
No.
Now you want one?
Yeah.
That's okay. I'll enter a not guilty plea for you. We're going to set her up with a lawyer and then the lawyer can take it to the prosecutor. $500 personal bond. You cannot leave the state without the consent of the court or violate the law. You must appear in court as directed. Do you understand all that?
Yes.
All right. Any questions?
No.
So he's going to set you up with a lawyer. The lawyer will talk to the prosecutor. And again, either way, you're coming back in front of me. Okay?
Okay.
Good luck.
Who are you waiting on with her?
Her lawyer.
Oh, your name is Deal?
Yeah, if she's ready.
She wasn't in her office. I don't know where she went.
Well, let's let her work on a couple others. I'll get off here and ma'am, then I'll come out and take yours when the lawyer's ready, okay? You understand?
Yes.
Okay. You can stay seated.
I can get my sweater out of the car.
Pardon me?
Can I get my sweater out of the car?
Of course you can.
Easy.
K. Hamilton.
Court of Land Session.
People against Alicia K. Hamilton. This is file 2, Court of 834317.
Good morning, Judge DeAndrea, on behalf of Ms. Hamilton, state your full name for the court.
Can I take a peek here? She doesn't have the best record. I mean, I'll do this, but she's going to plead to retail fraud, 771.
Yes, Judge.
Is that what you want to do, Ms. Hamilton?
Yes, sir.
If you plead guilty here, the possible penalties are up to 500 fines, 90 days jail, costs are all those. That's under local ordinance. Do you understand that?
Yes. Yes,
Did you sign the advice of rights?
yes,
Did you read it and understand it?
yes,
If you plead guilty, you'll be giving up all those rights. There will not be a hearing or a trial. Do you understand that?
yes.
For the charge retail fraud, how do you plead? I can't hear you.
Guilty.
Were you at Walmart at 2380 Allen Road in Woodhaven, May 14 to 24, 2:13 p.m.?
Yes,
Did you take property there offered for sale without paying for it?
yes,
And it says here there was $100.88 worth of merchandise, true?
yes,
And you did walk past the register without paying while the store was open to the public, is that true?
yes.
Are you on probation?
No,
Parole?
no,
Anybody forced to plead guilty?
no.
Please accept it. All right.
Judge, I understand the court is probably wondering where Ms. Hamilton has been since this was May 2024. She's had some family issues. She had gotten sick for a little while and then she was diagnosed with MS, unfortunately. Her daughter just gave birth, so she's helping her daughter out with her granddaughter. She
I need
will be
a
receiving
probation
Social
order.
Security in December 2025.
She'll be, okay. Anything else? I'm gonna just go ahead and sentence her now.
Okay.
Anything else you want to say?
No, that just, she's had a lot of family issues that she discussed with me, so she does apologize for her absence.
Ms. Hamilton,
Yes,
anything that you would like to tell me?
I just made a big mistake and I'm very sorry.
Why'd you do that?
I honestly don't know. I just made a mistake.
And Judge, the store, the property was recovered.
Yeah, I get it. All right, so the agreement was it would be taken under section 771.1 for 8 months. If I've let everybody finish, I'm gonna go ahead and sentence. If I let everybody finish, ma'am?
Yes, Judge, thank you. Do you have anything else you want to say to the court?
8 months probation under section 771.1. You cannot leave the state without the consent of the court or violate a law. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. I'm going to order that you not enter. You're not to enter 23800 Allen Road in the city of Woodhaven or any other Walmart store. Do you understand that?
Yes,
You're to serve 2 days of community service. Two days of community service, you have to have that completed 16 hours. I'm gonna give you until, I'll give you until October 1st of 25. $100 fines, 75 costs, 75 victims' rights fee, $50 justice assessment, $300. There's probation fees of $160 plus attorney fees of $40. Your total's $500. You pay that, you stay out of trouble, you do your community service. I'll be happy to dismiss the case on motion of the prosecutor. If the person who was the third-party poster, James Garbajek, is he going to let you apply the bond?
yes,
Okay, so he's going to have to make arrangements. You have to call. Is he here?
no,
So is there a reason he can't come in or call today? I'm going to let you go talk to Lisa.
He can call today. He works midnights.
All right, so you pay $180 today. Then how much can you pay monthly or weekly or bi-weekly?
I could probably pay monthly. I have no income yet.
How much monthly can you pay? $75?
About 100.
Okay. You pay 180 today. You pay you pay $100 monthly, and I'll start that beginning September the 15th. If you ever don't have the money, call the court. We'll go on Zoom or come in here on or before the due date. I'll give you an extension. Your review hearing date in this case will be in, May?
I had April. Did I figure that wrong?
Yeah, April. April what?
April 1st at 9 o'clock.
So you're gonna go down the hall, get your notice. You're gonna go over to take care of paying that money. And you're gonna go over to probation and they'll instruct you. Okay?
Do I have to have him with me?
Go talk to Lisa. I think you're gonna just let him call in, right, Lisa?
Yeah, if he didn't sign it, then he can just call me.
Okay, so go down and talk to her. She'll give you the notice and then go see probation.
Thank you.
Stay out of here. Good luck. Do we have anything else down there? McLaughlin. Ariana Anne Marie McLaughlin. Well, I can get yours. What do you have next? Or are you Mr. Carmen? You have Ms. McLaughlin?
Yeah.
Okay, I'll take this one and then we'll figure it out. Ariana Anne Marie McLaughlin, 25B149-179A and B. Okay, Mr. Carmen, your name?
Morning, Your Honor. Michael A. Carmen, P7324
Ma'am, your name?
Ariana.
So we're going to adjourn this for clearances. You're going to have to fill out a petition for a court-appointed lawyer. I arraigned her at the conclusion of the arraignment. She said she wanted a lawyer. I thought I'd give her one and let you pre-trial. Now she's going to have to fill out a petition though. I'm going to give you an adjournment. What are we going, the 27th, Lisa?
Yes, 27th at 10 o'clock.
So you have to go start taking care of those clearances, okay?
Okay.
All right, and you're going to get your new notice down the hall. It's August 27th at 10. Any questions? All right, thanks. Michael Anthony Franklin. 25B149-184A and B.
Michael A. Carmen, P7324 on behalf of the Senate, Your Honor.
Sir, your name?
Michael Franklin, Your Honor.
All right, does he stand mute, wait formal reading?
Yes, Your Honor.
I'll enter a not guilty plea. $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'll give you an adjournment. You go take steps to get a license. Give me a date if you would, Lisa. And you're gonna have to fill out a petition for a court-appointed lawyer today if you want another lawyer going forward, all right?
August 27th at 10.
Okay, August 27th at 10. Anything else, Mr. Kerman?
No, sir.
Thanks a lot. Go down the hall, get your notice. We'll see you back here, sir. Thank you. Sebastian Counts. 209-8745-2B.
Good morning, Judge Bianchi. On behalf of Mr. Counts, make sure to move into the court.
Sebastian B. Counts.
Where's he been?
He's in a treatment facility, share house.
I know, but he's not been here in 4 years. Where you been?
I was in active addiction. I just wasn't taking care of the things I was supposed to take care of.
This is a leaving the scene of a property damage accident, right?
Yes, Your Honor. So the property damage piece of this is gonna be dismissed because there really was just damage to Mr. Counts' vehicle. He had a tree.
Well, what's he doing with the other one? You got an expired license that wasn't addressed.
So the prosecutor looked up the drove while license expired and it says dismissed on register of action. It says dismissed by party. So.
Can you see that, Lisa, on file A? I don't even have the file A here. It couldn't have been dismissed, I don't think.
We look at the ROA. That's what it
Did you have A?
There's a note in here from 2021, dismissed by party. A ticket should not have been written due to mandates.
Okay. All right,
So I think-
good enough. So he's just gonna plead to what? Allowing unlicensed driver? Is that what it is?
Yes, Judge.
If you plead to that, I'll dismiss to leave the scene. The possible penalties are up to 500 fines, 90 days jail costs, or all those. Do you understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes, sir.
To the charge of allowing unlicensed driver to drive, how do you plead?
Guilty.
Were you in control of a 2017, it looks like, Chevy that was being operated on Meridian near Groseville Parkway in Groseville, October 28 of 20?
Yes, Your Honor.
Did you allow somebody to drive that was unlicensed, and was that you?
Yes.
Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
Please accept it to that charge. To leave the scene is dismissed. I'll go ahead and sentence. Anything?
Just like I said, he's a share house. He only works the front desk maybe a couple of days a week. So I would ask the court to take that into consideration when ordering the fines because he will need a payment plan.
Anything you'd like to say?
Just, I apologize and I'm trying to right the ship.
Okay, 100 fines, 200 costs, 75 victims' rights fee, $50 justice assessment, 4.25, 90 days. How much can you pay per week or bi-weekly?
I can pay 50 bi-weekly.
Okay, I'll start you on August. Can we start on August the 25th? That's a week from Monday.
Yeah, I can do that.
If you don't have the money, you come talk to me, okay?
Yes, sir.
Whether by Zoom or in person, on or before the due date, I'll give you an extension, just don't need money. Okay? Thank you.
Thank you, Judge.
Do we have one with the interpreter ready to go? Who's the defendant on your case?
She never checked
Diego Sanchez, and I spoke with his attorney, Your Honor, and does not appear to be here again.
Where's the lawyer at? Who's his lawyer?
It's an arraignment pretrial, Judge.
What is up with these guys?
Never showed up.
Well, I gotta get her out of here. Can you get the file for me? What city or township was that?
Oh, I don't have that up.
Tabitha, or,
It was a Groseville arraignment pretrial.
Yeah.
Sands.
Jesus Christ.
I'll
Can you
look
go?
for the attorney.
Okay. I need that file. It's Groseville. Yeah, we gotta expedite that. Brianna Ray Barnier, 25B148-694B.
Good morning, Judge. Deanna Petit on behalf of Ms. Barney, they just want to report.
You didn't go over and set up for probation. I ordered a pre-sentence report.
Your Honor, I don't know if they have her right number, but she said she called a couple days ago, court is today. Probation says that they called her.
So the defendant was ordered to appear in probation to complete PSI, July 30. Defendant did not appear. Probation attempted to call defendant on phone and police report. Call would not go through. Busy signal only. August 8, probation attempted to call defendant again. Still no response. You got to go over and get a pre-sentence report done. Okay? We're going to reset the sentence, but I don't know why you didn't go over there. I think I made that clear. What day are we doing, Lisa? August 27th?
Yes, 8:30.
At 8:30. Go over to the probation department. Wait a minute. Go down, get your notice, and then go over to the probation department and get your PSI done. Thank you.
Thank you, Judge.
I need the lawyer on that case.
He'll be right in, Your Honor.
Thank you. Mora Diego Fernando Sanchez, 255-415-027. I'll tell you, I'm getting uptight about these guys. We get them interpreters and they don't show up. Come on up here, Mr. Wayne. So I don't know what's going on, but so the interpreter case, is your name?
I'm sorry.
I need your appearance.
Yes, sir. Good morning, Your Honor. Matthew Wayne on behalf of Groseville Township.
I don't know what's happening. I get these interpreters, we're paying them money and money we don't really have a lot of, and no disrespect to Ms. Villarreal, she does a great job, but then these characters aren't showing up. I'm getting a little uptight about it. I mean, I'm gonna issue a warrant for him. I don't know why, why did we cancel the warrant on July 30? Do you remember, Lisa? It looks like the defendant didn't show up then either. Maybe I'm wrong.
He was scheduled for July 30th. I'm assuming he was here.
Yeah, he didn't show up then either, did he? Anyway, this is what I'm doing. I'm gonna issue a bench warrant. I'm gonna forfeit the bond.
Oh, Judge, it was all in the same day, so I'm assuming he showed up late.
I'm gonna say 5,000, 10%. Warrant to issue, bond to be forfeited, 5,000, 10%. I'm sorry we had brought you in here, Ms. Villarreal. I really am. Thank you very much.
Thank you.
Have a great day. Thanks,
You
Mr. Wayne.
too.
Thank you, Your Honor.
Nicole Pish or Pish, Nicole Marie Pish, 2488333913, A and B, and I also have, that's it.
Everyone has that in college.
Your name, ma'am? You know, it's getting to be the rule, not the exception, that these people show up years later. I don't get it. I'm gonna lock the doors one of these days. I don't get it. I just don't understand it. Where you been? Yeah, you.
I tried to call to see if I could get another, date. My kids.
And what are we doing? It's telling you no? What's that?
My daughter had broken her arm, got hit by some fighters.
Ma'am,
I had to drop my school.
ma'am. This ticket was issued in March of 24. This is August of 25. And I know this because I know I feel a lot older than August of 25 than I felt in March of 24, and that's been 17 or 18 months. I'm just saying, a lot more pains and all that other stuff that goes along with it.
Honestly, I never got the court date.
Oh, boy. Did they give you the ticket? They gave you a ticket, right?
Yes.
And it said to show up, right? It said to call the court within 10 days. We sent you a notice. Do you live on Ogden?
Not anymore.
When did you move from Ogden?
A long time ago. A long time ago, I had lost that house.
Before March of 24?
Yeah.
Well, why'd you still have that license, that listed? Listen, why'd you have that listed as your address with the Secretary of State if you moved out of there a long time before that?
I haven't had, I didn't have a way to get there to change my address at that time. Yeah.
What am I supposed to do with this? You tell me. She's standing mute, waiting, waiting?
Yes.
Do you work, ma'am?
No, Your Honor.
How are you supporting yourself?
Well, I was working in Point Island, but I'm trying to go back to the airport. It's a better job. So it's what I need to do.
So her license is still suspended. She needs to get everything cleared to be able to work at the airport, so she came in today.
I even said she could appear by Zoom in March of 24. She must have had communication with my judicial clerk. Does she have money with her?
No.
Of course not. Of course not. So now she brings her kids, right? Brings her kids. Are these your two children?
Yes.
I think the system's failing. I really do. What am I supposed to do now? Lock them up, lock her up and let the kids, we can. I don't remember things being like this, Mr. Haynes. I don't remember people thinking they could walk in a year later, 2 years later, 5 years later, 7 years later and act like they're coming here to dinner. I'm I'm serious. I just don't remember them doing this so much until the last few years. I don't know what's going on. I don't know if COVID. Give you a $500 personal bond. Next time, if you miss again, you better not bring your kids or bring a lot of money, like $1,000, because that's what I'm going to set as your bond. And you're going to be sitting back there until you can post.
Okay.
Do we understand one another?
Yes, sir.
Stop playing games on this. Lisa, give me a date.
August 20th at 9:30.
Do you understand that?
Yes, Judge.
Do you have an address for us?
You can have, it has my mom's address.
You give that to my judicial clerk when you walk down the hall. Okay?
Oh.
If you haven't changed your license yet, or your address, you gotta clear all your suspensions, whatever they are. And by the way, you owe $195 on this improper plate ticket.
Yeah.
So you better come up with some money, okay?
Oh.
How old are your kids?
4 and 6.
Wow. How you guys doing? You enjoying the courthouse? Yeah, I'm just having fun. Relax. I don't know why I'm having fun with people not showing up all the time. Pretty soon, he's gonna walk in a year and a half later and say, I couldn't get a ride to work. What did I give him? Did I even give a date yet?
August 20th.
August 20th. Down the hall, get your notes. I wish you well. Good luck. Have a good day. Be more responsible, please. Thank you. Cole. Marcel Cole. Marcel LaQuinn Cole, 25B1486628 and B.
Yes, Marcel Cole.
Who's your lawyer?
Oh, okay.
Come on, stay right there. All right. So you're gonna, well, let's wait. All right, Ms. Patillo, your appearance.
Yeah, Patillo, on behalf of Mr. Marcel, did you already say your name?
Marcel.
It's Mr. Cole. Marcel's his first name, right?
Yes.
It's okay. All right, so he showed up on time, one of the few who've done so. And he stood mute, waives formal reading, and now you're gonna have him plead, or the prosecutor is agreeing to let him plead to allow an unlicensed driver to drive, and distracted driving, to suspend and no insurance to be dismissed. True?
Yes,
Is
sir.
that what you wanna do?
Yes, sir.
Do you have insurance now?
Yes, sir.
If you plead guilty to allowing an unlicensed driver to drive, that is punishable by up to 500 fines, 90 days jail, costs for all those. If you plead to distracted driving, that's 0 points. You won't get any points. And I'll dismiss both the other charges on motion of the prosecutor. Do you understand that?
Yes,
And did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you will be giving up all those rights. There will be no hearing or trial. Do you understand that?
Yes, sir.
To the charge, allowing an unlicensed driver to drive, how do you plead?
Yes, sir.
Were you in control of the 2021 Chevy that was being operated on Telegraph near Sibley in Brownstown, July 20 of 25?
Yes, sir.
And you were unlicensed or suspended at the time, true? Are you on probation or parole?
Yes.
For what? For what?
For the charge of the 3 weeks ago.
You have an OWI on your record? That was in Plymouth?
Yes, sir. October 30.
All right. Do you understand by pleading guilty, this would be deemed a violation of your probation? I can't hear.
Yes, sir.
Do you still wish to plead guilty?
He has some more questions, Judge, we can ask him that.
I'm so close to getting you.
I can't hear you.
I'm waiting for the hearing for the Secretary of State at any time for the hearing to get fully reinstated, so.
Well, that's Secretary of State.
Are you on probation to that court?
Yes.
I'm just telling you, by pleading guilty, July 20 incident, if you were on probation then, that probation could be revoked. You could be incarcerated on that charge as a result of this plea and conviction. You understand that? I can't hear you.
Yes, sir.
You still wish to plead guilty?
He wants to ask a couple more questions. It won't be long.
I understand. No problem.
Okay, just one second.
Do we have this defendant, Mr. Balint, here?
Your Honor, I just spoke to him.
He'll be here? So he needs to be set up with a lawyer.
Be here in about 15 minutes.
Okay, good. So we'll set him up with a lawyer then, okay?
If you need me for anything.
Now, probably not. I think do you have something to do? Are you really important?
I'm all yours.
Yeah, I think I'd prefer you wait on this one.
Okay, yeah.
And I'll arraign him as soon as he gets here, but he'll have to speak to a lawyer, so.
Okay.
We'll give him a lawyer. What's your name in the back, sir?
Jonathan Johnson.
What time is your case scheduled?
You already did this, Judge.
I did his?
Yes.
I did your case?
His, I believe this was an adjournment.
Was yours an adjournment?
Possibly, but I did.
Did you come up and stand in front of me right here at this podium?
No, sir.
Okay. Did you talk to a lawyer?
Well, I was on the phone.
All right. Hang on.
Caitlin submitted a stiff form this morning that he wasn't able to make it, so you adjourned it this morning, and I have it right here.
You're the one who said you couldn't get a ride?
Yes, sir.
Well, how'd you get here then?
Try my best. So.
All right. Lisa, we have that file I sent down.
Yes, you want me to run it down?
Yeah, we might as well try to take care of that today now that you showed up.
Okay.
Okay, thank you. You're okay. At least you made it here. All right. I don't know what she's looking for. So this guy was the one I adjourned because they said he couldn't make it.
Right. Dino just talked to him, I guess.
No. So now we're gonna have him set up with Caitlin. But he's gonna have to get, Lisa's bringing the file, so. No, that's not him.
Oh, I don't know who you're talking about that. I don't know who that is. What? You didn't check on me. What's your name? Joseph. Oh.
We called that at 8:30 or so. Or 9, I don't know. She sent it in and said he couldn't get a ride, so I agreed to adjourn it, but now he showed up, so I might as well set him up with whoever he's to be set up with. I don't remember if that was an arraignment.
What was his last name? Johnson?
Yeah,
Not even on the docket.
He's at 10 o'clock.
10 o'clock.
Oh.
Was that a drunk driving or suspended?
Where's his file?
Yes, operating.
The break that he just got it. Mr. Johnson.
Right here.
Oh.
Okay, operating on time. So, here, can I see that?
Want to see it?
Yeah. I think this was just an agreement.
Yeah, it's just.
Come on up here, Mr. Johnson. Yeah. People against Jonathan Patrick Johnson, 25B148931. A and B and C and 25B148932. Your name?
Jonathan Johnson.
So you're charged with operating while intoxicated, resist, hinder, and obstruct an officer, open intoxicants, and refuse a PBT. You have the right to a lawyer. If you want a lawyer, I will give you one at public expense. Do you understand that?
So,
Would you like a lawyer?
can I just speak, say something?
Let me give you a lawyer, okay? This isn't really the time to talk. This is an arraignment. And I think I'm gonna give you a lawyer. You should get one on these, all right? So I'll set you up with a lawyer. And that lawyer will talk to you, see who we can get to kind of expedite this one, John. And then you'll come back in front of me, okay? You all right?
It's supposed to be a situation.
Well, just relax.
It's a family function. Tell about it.
Listen, you gotta just talk to your lawyer first. You don't wanna be making any admissions here. I was drinking, I was drunk, I was driving, you don't wanna be doing that. Talk to your lawyer, just relax. Talk to the lawyer, and then the lawyer can come in here and represent you appropriately, okay? All right.
Thank you.
You're welcome. You know what? You don't have to stay. Go ahead.
Your Honor, I'm good. He said he just needs,
Pardon?
Mr. Ballard said he just needs to put some dress pants on.
Okay,
A polo shirt, his dad's free,
okay. Yeah. Bailey Leanne Dow, 25B, 148814, A and B on the A file. Defendant failed to appear. Second mess, bench warrant to issue, bond to be forfeited, 30,000, 10%. In the B file, already defaulted back in July for failure to appear. People against Magyar, Christopher David Magyar. 25B 473, A and B. These are second misses, 2,500, 10%. Failure to appear for show cause on each one of these warrants. Issue bonds to be forfeited again. 2,500, 10%. People against Sanders, Darrow, Levitt, Sanders, 25B 148573. Defendant failed to appear, 2,500, 10%. Warrant issue bond to be forfeited. People against Scott Luke Tackett, 25B 149006 A and B on the 06A file, 2,500, 10%. That's for failure to appear for show cause. And on the B file, I'll just go 1,000, 10%. That's an unregistered vehicle charge. So warrants to issue, bonds to be forfeited. Warrants to issue with those respective amounts. Ramonte Ronald Young, 25B 148-921 A and B on the A file, initial warrant, 3,000, 10%. And on the B file, default judgment was previously entered on that case back in July when the defendant failed to appear on the first occasion. People against Eliana Elizabeth Arroyo Geigel, 25B 148-667 A and B on the A file. Issue a warrant. This is the second miss. Failed to appear for show cause, 3,000, 10%. The B file was already defaulted back on July the 17th or thereabouts. People against Sadie Costello, 25B 149-147 A and B on the A file. Will issue a show cause. That's to suspend, and defendants in default on the distracted driving charge. Stephen Lee Miracle, Jr., 25B 148-937. Defendant failed to appear. We're going to issue a show cause on that one as well. All right, so as soon as somebody gets that back in here, we'll come out. Thanks.
Case number 23. Days of jail time. By Mr. All right, this is the case of the state of Ohio versus Paul Goshorn, case number 23 CR 42591. Present before the court is Mr. Goshorn, represented by Mr. Aldridge. We have Mr. Lee from the prosecutor's office, and Officer Fisher from probation. We're here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor.
Is there any reason not to go forward with sentence today?
None.
We have 38 days of jail time credit, $250 in reimbursements. Did we or are we filing a affidavit of indigency regarding the mandatory fine?
I was discussing it with the prosecutor before we went on the record, Your Honor. I believe it's the state's position that there is no mandatory.
I don't think
fine
there's a
in this.
mandatory fine on an F3 possession. There is on the traffic.
Oh, okay.
We did not include that on the plea, but
Okay, so we agree there will be no fine.
yeah.
Okay. Mr. View, anything on behalf of the state?
Your Honor, we have been in contact with the victim on the receiving property case. There has not been a request or response for our request for information regarding restitution. The trailer was recovered and returned. So in terms of that, in terms of the state's recommendations for sentencing on the case, as the court's aware, the defendant was on supervision at the time of the offense. He has an extensive prior history of theft-related offenses and drug offenses. He has a history of failures on supervision, revocations of his probation, and multiple prison sentences. All of that criminal involvement and treatment that was directed towards him has failed to correct his behavior. The state does not believe that Mr. Goshorn is a good candidate for community control. Our recommendation on the case as to count one, the felony of the third degree, is a 24-month prison sentence with a concurrent 12-month prison sentence on the RSP.
Anything from probation?
Nothing further, Your Honor.
Mr. Aldridge?
Your Honor, to correct a couple of things that I said during our pretrial, regarding Montgomery County, it was my understanding that they were considering ILC up there. Sounds like that is not the case because of issues with this prior record. However, they are keeping the charge a felony 5. He has a plea up there tomorrow on that. The expectation, hopefully, that he'll obtain probation on that case as well. He is on probation now in Hamilton County. It sounds like he's been compliant with them. He has started engaging in drug treatment. What was the name of it again?
State Line in Harrison.
State Line. It's where he is engaging in treatment currently. Again, I don't disagree with the prosecutor that his record's awful, but clearly this is substance abuse based. I think the treatment is the priority at this point.
Mr. Goshorn, what do you want to tell me?
There are details. I mean, I'm not going to argue the facts. I've been in trouble. You know what I mean? I don't think it's as bad as or some of the things could be misunderstood or saying that I've not completed probation and stuff like that before. And as far as drug charges go, so yes, I have the drug charge in Montgomery County, but other than that, I've not had drug charges prior to, the last couple months. regardless if they were my drugs or I were around other people, you know what I mean? I'm taking responsibility for that because I was around those kinds of people, you know what I mean, along with using as well. So I know that I'm guilty in that part, you know what I mean? Regardless if I was using or not, I'm still around bad people, places, and things. During this time, I lost my grandmother while I was locked up in your guys' county, and to me, that was like my last straw that I wanted to cut all these people, places, and things out. And I'm trying to move forward with the IOP, and I've never had any kind of treatment before. The only thing I've ever took, so I have been in prison before, and the only thing I did before was like AAs and NAs. But I'm in the IOP right now. I've been going twice a week. I've been there for 3 weeks. That's what's going on there. I'm taking urine tests there. I've been clean on all my urine tests with you guys, and I'm looking to move forward and continue with the positive thing out here with my life and everything now. Because my grandmother left me the house, and me and my fiance live there currently. But my uncle is the overseer, so we're in the process of actually like buying the house because some of the shares were left to the family. So I'll actually be buying the house from them. So I've been in that house for 30 years. So I'm a resident of Hamilton County. This is my first time being in trouble and stuff up here. So I've been a resident in that house for 30 years. I am working, but with it's pretty much like part-time right now because of having to go to the programs and go to take urine samples and all that stuff like that. So I'm not really full-time right now until I can get more on a steady schedule of getting done with all these court dates and everything like that. So I am due to go to Montgomery County tomorrow, and they're talking about probation and possibly a courtesy probation if I get on probation here because they said you guys have the bigger charge. But it is at F5 up there. Hamilton County, I owe them some fines, and they're talking about terminating probation. I go to see them on the 20th of this month. But I have been compliant. 2013 is when I messed up on probation in Hamilton County, and I was sentenced to prison. Other than that, I've always been compliant with probations, urine screens, and all that stuff. But I've never had any kind of drug treatment before. And I'm in State Line at Harrison.
So here's the thing, Mr. Goshorn. You know, for somebody who has a record like you have, you don't really get the benefit of the doubt when you come to court. But also, you know, I don't generally send drug users to prison. That doesn't make a lot of sense to me because it doesn't further the objectives of protecting the public. It doesn't serve the objective of really punishing you that much. There's no rehabilitation in the institution, at least not that I have observed. So here's what I'm going to do. I'm going to put you on 3 years of basic probation, and you are going to abide by the standard rules of probation. I'm going to order that you enter into and successfully complete outpatient drug and alcohol treatment. And you need to pay the $250 in reimbursement. I'm not going to impose a fine. I am going to impose the costs, and I'm going to give you credit for the 38 days in jail that you have already done. So you and Officer Fisher are going to sit down in this case, right? This is your case, right, Officer Fisher?
Yes.
You and Officer Fisher are going to do the regular probation thing between now and probably February-ish. So when we get to about 6 months into this, we're going to have some decisions to make. If you are paying if you've paid the reimbursement and you did your outpatient treatment and you're abiding by the rules, she's going to convert you to non-reporting probation, and we're just going to run your record and make sure that you don't steal anything from anybody else or pick up any new drug charges.
Yes, sir.
If you don't, then life is good, and we're going to assume that the outpatient treatment did its work. Because I don't want to put a lot of effort into you in terms of that. And hopefully that'll work.
Can I continue treatment where I'm at now, or do I need to switch to your guys'
So
county?
if you're treating, I mean, if you're treating in some church basement or something, you know, with a couple of guys, we're not going to do that.
No.
But, you know, Officer Fisher's going to check out the treatment. If it's a certified treatment provider, we'll go with that. I don't really care where it is that you do your treatment. Get it Show us that you can pass drug tests, which you've already been able to do, and don't take stuff that doesn't belong to you. It's really not that complicated, and I don't want to make it that complicated, because if you can't abide by those simple rules, you just need to serve out 180 days in jail with us and be done.
Yes, sir.
All right. If you do, though, leave the state without permission or you violate the terms, I could send you to prison for the maximum penalty, which is 36 months in prison, plus the optional period of post-release control of up to 2 years. Anything else?
Nothing further from state
All right. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they will all be provided to you without charge. Good luck to you.
Thank you, sir.
Kwame 25 CR 42348.
Judge, before we start with the plea, Mr. Trawick has told me that he would like to call around and look to hire another attorney. So I'd be asking to withdraw at this point.
Okay.
Ms. Williams is asking the same, Judge.
All right. So here's where we're at. We're here today for a pretrial on both of these cases that have been dragging on for too long. I am very interested in getting these cases resolved because we have made zero progress in this case, in both of these cases, in the last 6 months. We were kind of accommodating in how things were going forward. We let you attend, at least initially by Zoom. We pushed one of these cases back. I don't remember which one, so that you could travel here together because somebody was in jail somewhere. And
that's one reason why we have not had a lot of time to communicate, because Mr. Trawick was in jail. He just wanted me to let you know that.
And quite honestly, I am running out of patience in this case. And I want you both to have the opportunity to be represented by counsel. I appointed you both good lawyers who regularly practice in this court. And if there is this notion that, oh, you know, I'm going to go hire a lawyer and I'm going to get a better deal, you know, that doesn't happen. But here's where we're at today. And the reason that I'm putting this on the record today is because we sort of had an agreement as to how this case might go forward today. And if this case doesn't go forward like this today, it's probably not going to go forward like this in the future. There was a discussion that each of you were going to go ahead and enter pleas of guilty to F5 theft charges. That is a felony of the 5th degree, punishable by up to 12 months in prison. We were going to set this out for a sentencing hearing in about 8 weeks or so. If you came with restitution, it's different in each of the cases. It's, I think, $2,700 in one case, $1,400 in the other case. If you came to sentencing with the restitution, then we were all going to sort of agree to ignore the rules of criminal procedure and amend this to a charge that is a misdemeanor charge at the sentence. And then instead of a felony on your record, we would pay the restitution and you would have only a misdemeanor on your record. I would place you into my community control program, would have you serve some amount of local days, put you on non-reporting probation so that we can make sure that this doesn't happen again. If in fact we are not going forward with this because this requires everybody to be in agreement, not just the two of you and your lawyers, this also requires that the state of Ohio be in agreement with that in order to get this charge amended to a misdemeanor. They want to get Best Buy their money, and that's probably why they are agreeing to this. I'm perfectly willing to give you both a continuance so that you can figure out if you want to hire another lawyer or whatever. I don't have an issue with that, but I want to make sure that we put it on the record that Mr. View, who has not yet weighed in, but I am sure when he does, is going to tell me that if we don't do this today, he is not going to agree to this in the future. Am I right about that, Mr. View?
Absolutely correct, Judge.
All right. So let's take the cases in order when they are on the docket. So Mr. Trawick?
Can I say something?
Sure.
it wasn't no problem with the bill. I think the plea deal was perfect. It was just that the jail time, is it a way we could do like probation or something? Instead of jail time?
No, if you are in fact guilty of this offense, based upon what I know so far, part of my agreement, because I have to agree to all of this also, is that you both need to see the inside of my jail.
And how much time is that?
I think we had talked about 30 days. I don't know what time served we already have in the case.
Can I ask a question?
Yes, Ms. Williams.
I didn't technically agree with everything. I was okay with it, but I didn't technically tell him even the last time. My only issue was saying, can I get a second opinion? Is because I have no communication with him. To my knowledge, he hasn't even received a discovery. So it was just more so of communication on both ends with all parties. That was my only thing. We don't have communication. I've been through the wire before with having public defenders, and this is by far the worst communication that I've ever had. I'll email him. I'm lucky if I get an email back. That was my only issue. Second, when he told me that, the jail time is fine, but I have an 8-year-old son. I'm okay with that. But when you be like, I don't know, between this amount and then, but it'd be up to 30 days, I have to make arrangements. It's just me with my son. I have to make arrangements for him. So I can't just say, well, here's somebody, but I don't know when I'm, I have to know at least some type of time frame that would be like if maybe in your head you have an exact amount of days, but I just can't, I'm gonna agree to this, and then it turned out I done set aside maybe 2 weeks for him. I don't want my son to be in the system for this. I went to therapy. I've done a lot of things, and I haven't been in any trouble since then. And so I'm sorry, I just
That's
was
okay.
trying to do everything on my end because I don't have nobody for my son.
Here's the other problem that I have in this case, Ms. Williams, that doesn't have anything to do with any of you. I sort of think that 30 days is the right amount of time. But if I give you both 30 days, okay, and Mr. Trawick goes to work in the litter pickup program, and let's say he goes out in that 30-day period, let's say he goes out 6 days on the litter crew, he would get credit for because I give people additional jail time credit for the time that they do on the litter crew. So if he went out and did 6 days of litter, he would get out 6 days sooner than you. You can't do litter because it's not eligible for our female population. And I don't know that I would feel really good about you being in jail longer than him. So if he got out 6 days sooner, I would probably let you out 6 days sooner. That's why I'm sort of in the general vicinity. It's not going to be any longer than 30 days as long as everything goes according to plan. But if you show up, test positive for drugs, for example, and also bring your restitution, then it might be different. Do you understand that?
Yeah. And one more thing. He would possibly be my help. So us both going in at the exact same time when
Doesn't matter to me as long as this gets done in the next 90 to 120 days or 90 to 120 days from the sentencing, I can live with that.
Today's the sentencing.
Nope, the sentencing will be 8 weeks from today-ish to see if you have the money or not.
Okay.
But here's the problem, and I don't want to prevent you from being able to get a second opinion from your attorney, but your attorney, let's say that you drove down the street and found a really good private criminal defense lawyer. I am 100% sure that that criminal defense lawyer would say to you, wow, it's just in Warren County and they are going to reduce a felony to a misdemeanor. That almost never happens in that county. That is a really good deal. And you're going to say to them, oh, well, the deal is gone now. And then he or she is going to say, oh, that's very unfortunate. I don't know what to do about this because I only have control of 1/3 of this. I have control over my third. You have control over your third. Mr. View has control over his third. So if you guys can reach an agreement today, I'm fine with that. If you can't reach an agreement today, I am fine with that also. Not punishing anybody for not agreeing to the deal today. But it seems like a really good offer.
No, I'm not disputing that it's not.
But it might be gone after today if somebody doesn't enter a plea of guilty today. I can't control that. I don't know that I even really disagree with Mr. View that we got to get this going, but that's where we're at. So we all got our lawyers here today. We all got time to talk and figure out if this is what we want to do today. And if it is, I want to make sure that everybody is clear. We plead guilty to a felony today. We set it for sentencing in 2 months. If you have the restitution in 2 months, then Mr. View is going to agree that we're going to take this down to a misdemeanor. I would sentence you to no more than 30 days in jail, and that 30 days in jail would have to be scheduled sometime within the next 3 months after that. Is there any ambiguity as to what we're talking about? Mr. View, did I misstate the way that we're going forward?
I think it's correct, Judge.
All right, we're going to break, talk amongst yourselves, figure out what we're doing, and then let me know where we're going.
Thanks,
All right.
Judge. Thanks, Judge.
All right, thank you.
This is CR 38451. Present before the court is Mr. Reber. Court is in receipt of a report dated August the 12th, indicating that Mr. Reber was on probation with us, that he was not granted ILC, he was successfully terminated from supervision, and we have about $797 that is due. I don't, though, see a cost bill. Oh, there it is. No, that can't be right. Oh, we do have a cost bill that says that $797 consists of $437 in clerk fees, $360 in supervision fees. So the way we do these cases, Mr. Reber, is whether or not you pay your court costs is a factor. It's not the only factor. I'm not going to tell you that if you don't pay the money, I'm not going to grant you your sealing of the record. It doesn't work that way. But think of it as a scale. On this side of the scale, we have all the reasons that I should grant you sealing your record. On the other side of the scale, we'll plop down that you didn't pay your financials. Most people say, hey, Judge, if you give me about, 3-4 months, I'll pay this off. And then I feel like I will be in a better position for me to decide the case. Some people, a smaller amount, say, I don't have the money. I'm never going to pay this. So do what you got to do. Where do we fall on this, Mr. Reber?
Well, since me being released off probation, I've gotten my life together and I'm still low income and I'm providing for a family now, and it's hard to make ends meet there. But I'm trying to start my own business doing mechanics. So I believe, hopefully, if that picks up, I can put some money towards what's due. But I don't know if I can get all 797 with being providing for a family.
Okay. Do you want to set it out for 90 days and have another hearing in 90 days and see where we're at on this?
See how much I can collect up in 90 days, yes.
Okay, let's do that then. Ms. Carrillo, who is the assignment commissioner for the next 13 days, will get you a new date. That'll be in about 3 months, and we'll see you back here then.
Thank you.
Okay? All right. Seat right here. State your name, please.
Ashley Burns.
All right, so Ms. Burns, we are here today pursuant to a request by the prosecutor to take your deposition because it's been represented to me that you are not able to be here for our upcoming trial. So first of all, could you state your name, please?
Ashley Burns.
All right. And Ms. Burns, what's your address?
I'm not gonna say that.
Okay. What's your address?
I'm not gonna say that in front of somebody that could come after me.
Is there a way we can
All
just
right.
leave
So
the city running?
here's the thing that I'm going to adjourn this hearing, and Ms. Burns is going to come back for the trial. And if she is not here, she is under subpoena. If she's not here, then you can decide what effect that has on your case, if any. When I ask questions, I get answers. Thank you, Ms. Burns. You're free to go. I'll see you back here for the trial.
Your Honor, if I can have just a minute with her, please, and just explain a few things. She's just. due to
Ms.
the
Burns,
nature of
I
the
understand that this
relationship-
is a scary process, but the way this works is Mr. Reefers is accused of a criminal offense, very serious criminal offense that carries with it serious consequences. He has the right to confront all of the witnesses against him that might happen. I know that it's just bad luck that you happen to see some things, but when we conduct a criminal trial, we don't conduct them in secret, and we don't conduct them hiding stuff from the various parties. And I can understand why you might not want to disclose the answers to the questions that might be presented to you, but what your name is and where you live are very basic questions that we are entitled to know the answer to those questions.
Is there a way
So-
where she could give just the street and the town without the actual address itself, Your Honor? Just because the Ms. Burns and the defendant was in a quasi relationship at the time, and she does not want the defendant to know
Objection,
where she
Your Honor.
currently
She-
resides. I'm just trying to
She
explain.
stated in her own words, in her own testimony, that we were not dating. It was our first date.
Oh, so you guys had a pre-existing relationship?
Yes.
I guess I'm not sure that I need.
Yes,
No,
that's-
it was the first night we had met.
They were Facebook, he had just come up to Ohio to meet her face to face, but they had been on a Facebook relationship, or at least talking. So
Okay.
that's why she's very hesitant to let him know exactly where she lives. That's the only reason. Your
Okay.
Honor.
I'm okay with a town
Okay,
and a state.
perfect. That would be
Do
okay.
you want to talk to Ms. Hyatt before we get going again?
Yes, please.
All right, let's do that.
I'll be. Your Honor, I believe she's fine with proceeding, Your Honor. Thank you.
All right, Ms. Burns, could you state your full name and spell your first name and your last name?
Ashley Rebecca Burns, ASHLEY,
And where is the town and state in which you live?
New Albany, Ohio.
All right. We have a trial that is set for September the 9th and the 10th in this case. It's my understanding that you're not available to come back for that trial. Is that right? Why is that?
I'm going on vacation.
All right. Is this a pre-planned kind of thing?
This is.
All right. Any questions about that limited issue?
No, Your Honor.
Any questions about that limited issue?
I would object on the grounds that a vacation would be irrelevant, but we'll leave that to the court.
Okay. All right. So I am going to grant the request of the prosecutor to do a video deposition and perpetuate the testimony for the purposes of trial. So what's going to happen, Ms. Burns, is I'm going to place you under oath again, which I know sounds a little odd, but we're going to stop the recording and we're going to start the recording again because this is going to be played for the jury at the trial. So it'll be like we're starting over again, but the jury is not going to hear the discussions that we have already had. Do you understand that?
I do.
All right. Anything else preliminary before we do our hard restart?
I don't believe you. No, there. Thank you.
Is she going to have to draw on the picture? Did we get that problem fixed?
No, she won't have to draw. It's just a photograph.
Okay.
And I showed that to the defendant.
All right. I'm taking us off the record. All right. Ms. Hyatt, call your next witness, please.
Your Honor, we are calling Ashley Burns.
Ms. Burns, could you raise your right hand for me, please? Do you swear or affirm that the testimony you give in this proceeding will be the truth, the whole truth, nothing but the truth, so help you God? Ms. Hyatt, you may proceed.
Thank you, Your Honor. Ms. Burns, good afternoon. Sorry. Can you please tell the well, we'll be the jury. Where do you live?
New Albany, Ohio.
And just so you know, this courtroom gets a little bit, if you can just keep your voice up, because they're going to have to be able to hear you. And I want to make sure we have good volume when we play this. And for the record, did you used to be a defense contractor?
I did.
Okay. And how long were you that?
4 years.
And did you have a clearance associated with that?
I did.
And do you still have a clearance at this point now?
I do.
Okay. And prior to working as a defense contractor, did you ever serve in the military?
I did.
In what branch?
I was in the Army.
And how long were you in the Army?
6 years.
And I want to just thank you for your service. As a result of your time in the Army, did you have any repercussions or consequences from your service in the Army?
I had a TBI, a broken ankle, and a fixed femur.
Okay. And so the TBI, the traumatic brain injury, does that affect you in any way still today?
Most days, yes.
In what way?
Memory.
Memory. Okay. And this, how long ago was the TBI that actually, the incident that caused it?
2018.
Okay, so about 7 years ago? You have to say yes or no
Yes.
because it'll pick it up. Okay. Now, in this particular case, we're asking about an incident that happened back on November 9th of last year. Do you have a memory of that incident?
I do.
Okay. And just so we know too, in order to become your job as a defense contractor, do you have any degrees that you, like college degrees as a result?
I have an undergrad in pre-law. I have a master's in business, with business law being the emphasis, and then a master's in aerospace engineering.
Okay. Now, I just want to ask you, do you know the person named Brandon Reefers?
I do.
And do you see him in the courtroom today?
I do.
And can you just point him out, describe what he's wearing in court today?
He's the defendant.
And what's he just wearing?
A dress shirt.
Blue?
Sure.
Okay.
Yes.
Just for the record, indicating the defendant Brandon Reefers, Your Honor.
Noted.
All right. Can you just explain to us, how did you first meet Mr. Reefers?
Facebook dating.
And were you residing, how long ago? Well, let me start. As of November 9th of last year, what kind of time prior to that did you begin speaking with Mr. Reefers on Facebook dating?
About a week, 2 weeks.
Okay, so
Somewhere
fairly
around-
short time or so?
Less than a month, I believe.
Okay. And at the time that you first initiated this Facebook dating with the defendant, were you residing in Ohio or somewhere else?
Ohio.
Okay. And was Mr. Reefers, to your knowledge, residing in Ohio or somewhere else?
With his mother in Ohio.
Okay. And had he been in Texas at any point?
Yes, he had claimed that he had lived there before.
Okay. And was he residing there immediately prior to November 9th of last year?
I don't know.
Was there any indication he was coming to Ohio to see anybody?
There was an indication that he was currently living in Ohio with his mother.
Okay. All right. And as a result of your speaking with the defendant online with Facebook dating, did you arrange an opportunity to meet face to face?
I did.
Okay. And at that time, why did you want to meet the defendant face to face?
We had mutual connection in law enforcement and military, and he presented very attractive.
Okay. And as of before everything on November 9th, you were wanting to meet the defendant?
Correct.
Okay. And I know you don't live in Warren County, but were you coming to visit Warren County for a particular reason back on November 9th?
I have a college friend that lives around here.
And for the record, who's that person?
Lindsay Davis.
Okay. And did you also know her husband, Robin Davis?
I did.
From college as well?
Yes, ma'am.
Okay. And how long have you and Lindsay especially been friends?
10 or 11 years.
So for a period of time?
Correct.
Okay. And have you visited Lindsay and Robin Davis before?
I have.
Okay. And do they have any children?
They do. They have one little girl.
One little girl. Charlotte?
Yes, ma'am.
Okay. And let me ask you, let's talk a little bit about the actual date of why we're here, which is, it was a Saturday, November 9th of 2024, sometime probably in the late morning time. Do you recall that date and time?
November.
November 9th?
Yes, ma'am.
That's Saturday? Okay. And when, my understanding is, were you at Lindsay and Robin's house that day?
Correct, yes.
Okay. And was the defendant meeting you that day, or where were you going to be meeting?
Yes, he was meeting us.
And was that at the Davis's house or somewhere else?
At the Davis's house.
Okay. And so that Saturday morning-ish time, the defendant came to the Davis's house. And do they live in Warren County?
They do, yes.
Okay. And was that the first time you met the defendant face to face?
Yes.
Okay. And can you just kind of walk us through how that progression of that day went from that point on, from the Davis's house and then beyond?
Yeah, we
Your
started.
Honor, if I could,
You
can I
may.
have Ms. Hyatt move the podium? It's hard for me to see the witness.
Probably the easiest thing for you to do, Mr. Reefers, is switch chairs and slide over a little bit.
That's what I was doing earlier.
It's a fixed podium. That's the logistics of the room. It's not great. All right, go ahead.
So you started off at the Davis's house. What did you and Lindsay and Robin and the defendant do?
We started at coffee, and then from there, we were trying to find a Christmas festival. The one that we initially had wanted to go to was really busy, so we had found another location. And then we stopped to look at boots and some Western wear. That was a common interest of the defendant and myself.
Okay.
Walked around and looked at boots and things like that, and then decided to just go find a place to eat, which ended up being 50 West or 52 West.
A local brewery?
Correct.
And that would have been in the one in Mason, I think?
I believe so, yes.
That's fine. I know you're not from Warren County. Let me just ask you, when you left the Davis's house, Lindsay and Robin accompanied you?
I rode with Mr. Reefers.
Okay, and that's what I was going to ask you. So Lindsay and Davis drove to this Christmas market or festival and then you drove with the defendant?
Correct.
Okay. And do you recall what kind of motor vehicle he had?
White SUV, I believe a Toyota.
Just going to show what's been marked States Exhibit 15. If I can just show it to the witness first, Your Honor.
Go ahead.
This is States Exhibit 15. Do you recognize that photograph?
I recognize the vehicle.
Okay. And does that appear to be the same type of vehicle that the defendant was driving that day?
Yes, ma'am.
Okay. And I'm not sure, can I publish?
You can.
I can. Okay, I'm just going to show this for the jury then.
This is what number exhibit?
It's going to be Exhibit 15, Your Honor.
All right, go ahead.
All right. And that would have been the motor vehicle or the same type of motor vehicle that you and the defendant drove around in on November 9th?
Yes, ma'am.
Okay. All right. And when you go to 50 West, just for the record, is that a brewery?
Yes.
Okay. And did you or Lindsay or Robin or the defendant partake in drinking any beer?
Yes.
Okay. And approximately how many beers do you recall you had that was it afternoon, evenings, or something else?
It was afternoon. There was an afternoon Ohio game on as well as WVU, so we watched both those games. I had approximately 3 beers.
3 beers. Okay. And do you know if Robin or Lindsay had any beers?
1 or 2.
Okay. And what about the defendant? Did you observe if he drank anything at 50 West?
Yes, 1 or 2.
A couple. Okay.
Yeah.
And let me ask you, are you cautious at all in ingesting alcohol?
I am.
And for what reason?
I had a clearance.
And is that something that could affect your clearance?
Yes, if I got pulled over, I could lose my job.
If you were driving and drinking. Okay. Thank you. All right. So at some point then, do all of the 4 of you leave 50 West?
Yes.
And where do you go?
We go back to the Davis's house.
Okay. And for what purpose?
Just to kind of hang out. We had a couple more drinks. Sat out back. Just kind of chatted. The conversation at the brewery was going well. It appeared that the defendant and my friend's husband were getting along very well. They're both Freemasons, allegedly. And I think there was a connection point there, which made him feel comfortable. Lindsay as well, with it being their home. So he was invited back for all of us to continue conversation.
And at this point, had things still been going well between you and the defendant?
Correct, yes.
Okay. Was there any plans for like eating or dinner or anything back at the Davis's house?
We had some snacks at the brewery, and then it was proposed to just do smash burgers and fries, things like that at the house.
Okay. And after you left 50 West, were you again driving in the defendant's motor vehicle?
Correct.
Okay. And did you make any stops, the two of you, en route to the Davis's house?
We did.
And where'd you stop?
It was one of the local liquor stores.
And for what purpose?
To buy alcohol.
Okay. And do you remember what kind of alcohol you guys purchased that afternoon?
I got a military branded bourbon. Had a horse on it. Horse soldier bourbon. It's an army bourbon for the special forces that went over into Afghanistan. And then I believe it was Weller Red that the defendant had picked up.
That Mr. Reefers did?
Correct.
Okay. All right. And then did you then continue after you left the liquor store? Did you then go straight to the Davis's house?
Correct. Yes.
Okay. All right. Now, had Lindsay and Robin proceeded from 50 West directly to their house, if you know?
I believe so.
Okay. And once you got back there, you indicated that you sat outside, did you have some drinks?
We did.
Okay. And what kind of drinks were going on at that point?
Robin was making old fashions. That's kind of always been his signature in all the time that I've known him. And then I believe Lindsay was drinking a couple of straight bourbons. It was kind of everybody was just drinking bourbon.
And do you know, was this bourbon that everyone was drinking, was it from your bottle, the defendant's bottle, or something else?
I don't know.
Okay. Were you pouring any of the bourbon, or was somebody else?
The men were pouring the bourbon.
I see. Okay. All right. And you have, if you recall, approximately how many bourbon-related drinks did you have, or drinks did you have that evening or afternoon?
Probably 3 or 4.
Okay. What about, did you observe anyone else having the bourbon as well? I'm assuming the old fashions?
Yeah, we were all drinking.
Okay. Was the defendant also having an old fashioned?
I believe so, yes.
Okay. How many, if you recall, how many approximately did Robin and or Lindsay have that evening?
We were all kind of drinking at the same pace.
Okay.
So probably 2 or 3 as well.
All right. And did you see the defendant drink 2 or 3 old fashions or something else, or?
He was drinking a lot of the Weller.
The Weller Red that he bought?
Correct.
All right. Was he drinking that straight or mixed, if you know?
I don't remember.
Okay. Do you know how much of that Weller Red bottle he drank?
Significant. I mean, probably down to the label.
Okay.
Objection, Your Honor. Speculation, we were all drinking the same bottle.
Overruled. Go ahead and continue.
And when you say down to the label, do you know like where the label is on the Weller Red bottle?
I'd say probably 3 drinks down.
3 drinks down? Okay. All right. And at some point, did you have dinner during all this, or was dinner before or after the bourbon drinks?
And we had 8 prior to coming home, and then it was like snacks. And then we had burgers and
burgers. Was that burgers like while you were partaking, like everyone was partaking in bourbon and drinking?
Correct.
Okay.
Yeah.
And was that inside or outside of the house that you guys were eating and drinking?
Robin was outside, tallow frying hand-cut fries, and then the rest of us were inside playing with Charlotte, the baby. And then there was a moment where the defendant walked outside to talk to Robin, just hang out, I suppose.
Let me ask you, Ashley, as people were drinking that evening, did you notice any change specifically in the defendant?
He became more assertive in his desire for physical interaction.
What do you mean by that?
He wanted to have sex.
Okay.
Objection, Your Honor.
Overruled.
Did he say that to you?
He did.
All right, and what was your response to when he said that's what he wanted?
I moved off of the couch. We initially were sitting side by side, and then I had kind of moved and then excused myself to let Lindsay know that we probably need to figure something out.
And okay, so let me start with, why did you feel like you had to move?
He grabbed my wrist and told me that he drove all this way and it better have been worth it. And that made me nervous.
All right, and then when you sat there, and where did you and Lindsay have this conversation?
Inside the house.
Okay, where he was sitting as well, or
No,
somewhere
I
else?
dismissed myself and said I need to use the restroom, and then Lindsay walked in with me.
Okay, and when you said you wanted to tell Lindsay that you have to figure something else out, what did you mean by that?
That our physical safety, my physical safety, was more important than the defendant getting belligerently drunk in the back of the house.
All right, let me go a little bit deeper. I'm sorry, but okay. So when you said your physical safety, at this point, were you in fear for any physical safety issues?
Not when Robin was sitting out there, but Robin had dismissed himself to the restroom, and he had grabbed my wrist and kind of made it known that he wanted to.
Objection, Your Honor, I never touched her.
Overruled.
He made it known that he wanted to stay.
Okay. To stay the night, you mean?
Correct.
Okay, at the Davis's house.
Correct.
Okay. Did you ever tell him, no, you're not interested in that night?
I don't believe a solid no was the answer. I just kind of brushed it off.
Okay, and then at this point, when you dismissed yourself, how was the defendant acting when you got up?
And he just sat there.
Okay. Did he appear to be under the influence at all to you at that point?
Objection.
Overruled.
Yes.
In what way? Can you just describe for us what about what you observed about him led you to believe that he may be under the influence?
Based off of his behavior when we had first started hanging out, to then consuming alcohol throughout the day, and then at the house, he'd become more assertive in his conversation, and very very focused on sex.
Okay. Was there anything else about him? When you say assertive, I guess I'm just trying to make sure in what way was he assertive?
He just was bringing it up verbally. Like anytime anyone would move, he would just say how much he wanted me and how I was different than everybody else and how he's never met a woman like me and with the military and commonalities and things like that.
And how did that make you feel when he was telling you all that?
Well, when it was sober or before we started drinking, it was nice to have a connection point of being military or law enforcement or having some of the same interactions or struggles post-service. In the moment, it didn't feel great.
Okay. So when you dismissed yourself, was he still sober?
No.
Okay. What do you tell Lindsay?
That he was being very aggressive in his speech on how much he wanted to sleep with me, and that probably wouldn't be safe given that we had just met and that their baby was asleep in the bedroom that I was like right beside the bedroom I was staying in.
Okay. Just so we know too, do they live in a 1-story, 2-story, or some other kind of house?
So they've got a finished basement and then 2 stories.
Okay, so like 3 levels. Okay. Now, after you tell Lindsay that he's being aggressive, what's the next thing that happens?
Robin comes out from the restroom and he said, well, I will talk to him. and we'll see what we need to do.
All right, and were you present when Robin talked to the defendant?
I was not.
Okay. Where are you and Lindsay when Robin was talking with the defendant?
In the kitchen.
Okay. All right, and what happens after that?
So Robin had asked him to leave. I believe it was very fraternal. Hey brother, I think we're going to bed. It's probably best that, you get on your way, kind of thing. And Lindsay and I had walked out to the front of where the garage is, because my vehicle was there, her vehicle was there, and we just kind of wanted to make sure he was actually leaving.
Let me ask you, when Robin asked him to leave because everyone was going to be going to bed, what was the defendant's response that you observed?
He didn't want to go.
Objection, Your Honor.
Before I rule on the objection, I'm confused, Ms. Burns. Were you there and observed this, or is this something that somebody told you later about how he reacted?
I was there.
Okay. The objection is overruled. Go ahead.
All right, so did he indicate verbally, physically, or something else that he didn't want to leave?
He indicated verbally that he'd like to talk it out and figure out what everybody was upset about. He asked for a moment to communicate, essentially.
With who?
With anybody, I think, at that point. I think there was confusion because Robin had came out and said, hey, we're all going to bed, after I had talked to Lindsay. And he was like, well, what's going on? And Robin was like, no, you need to go. So Lindsay and I had stepped out where the garage was, and he then proceeded to leave.
Okay. And when he was leaving, what was his demeanor like?
He was upset.
Okay. And was Robin out there with you in the garage area when the defendant left?
Yes.
Okay. And so it was you, Lindsay, and Robin?
Yes.
Okay. And did anything happen as the defendant's leaving?
He appeared to be backing up or trying to, but he actually moved forward in the direction of Lindsay and I.
In the driveway?
Correct.
Okay.
And then immediately backed up and hit the neighbor's bush and then the car.
Okay, I'm sorry. So he's backing out of the Davis driveway and hits a bush that is between the Davis's house and the next door house?
Correct.
Okay. And the neighbor next door had a motor vehicle parked in their driveway as well?
Yes.
Okay. Did you actually see him physically come in contact with that motor vehicle?
I did not.
Okay. Did you hear it, or how do you know that happened?
There were scratch marks on the vehicle as he had moved on. Once he had departed that driveway, there were scratch marks on that vehicle.
Did you go over and see him?
Yes.
Okay. So you did see at least some kind of damage to the motor vehicle?
Correct.
Could you hear it when he struck that motor vehicle?
No.
Okay. All right, let me ask you, you indicated that he was not sober at this point, and that was concerning to you because of his assertiveness or what have you. Was there a reason why you or anybody else didn't stop him from driving?
My physical safety at that point was my priority. He is a grown man and can make his own decisions, to include his alcohol consumption.
All right. After the defendant leaves, what happens next?
We all go inside.
And is there any further contact from the defendant?
He had tried to call, left some voicemails.
Who was he trying to call?
Me.
Okay. And about approximately, so we have an idea of time frame, he leaves, approximately how much time had passed before you received the first call from the defendant?
Oh, immediately.
Okay. And he left a voicemail, you said?
Yes.
And was there anything concerning about the voicemail to you?
Just that he wanted to come back and talk it out, that he was really confused, validated how much he liked me, how he wanted to figure it out, understand what he did wrong.
Did you respond in any way to have him come back?
No, I didn't answer.
You did not. How many times are we talking about that he called you after he left?
I think there were over 20 missed calls and like 7 voicemails.
Okay. At some point then, you said that you and Lindsay and Robin were inside and their daughter was upstairs in her bedroom.
Correct.
All right. At some point, does the defendant in fact return?
He does.
Okay. And at this point, where can you just tell us like where everybody is as the defendant's coming and the defendant pulls in?
Yeah. So he had left a voicemail that said that he was coming back and that he wanted to talk it out. I believe the words were, "I don't believe what you're doing to me, but I want to make this work. I want to figure this out. I'm coming back." And then I had told Robin and Lindsay that I believe he was returning. And Lindsay at that point was like, "He has exited this home without a welcome back. So this is a problem." She was concerned about her daughter asleep upstairs. So Robin got his shotgun and he instructed Lindsay and I to go upstairs.
Okay. Was Robin the only one who had a firearm at this point?
We all had firearms.
Okay. Had you brought your firearm with you?
I did.
Okay. Is that something you typically always carry with you?
Always.
Okay. And you said that Robin and Lindsay both had a firearm as well?
Yes.
Okay. And why did you feel, let me ask you, why did you feel the necessity to arm yourself?
I always feel the necessity to arm myself. I have PTSD.
Okay. So no matter who was coming back, you would make sure you had your gun with you?
Correct.
Okay. All right. Now, do you see the defendant return?
Yes.
You can see the motor vehicle. Does he come back into the driveway again?
He does.
Okay. And at that point, where are you physically in the house?
Physically, I'm upstairs.
Okay. And is anybody else up there with you?
Lindsay.
Okay. And I know we said Charlotte was up there originally. Is she still up there as well? Okay. Is she awake or asleep, if you know?
She's asleep.
Okay. And do you have any lights on upstairs?
No.
Okay. When you see the defendant pull the motor vehicle back into the driveway, what do you see him do once he parks?
I only saw him park.
Okay.
Because the steps lead to the front door. Robin saw him.
Okay, well, let's not go into what Robin saw because you didn't see that, right?
Correct.
Okay, that's fine. Let's go with just what you saw and observed. And do you see or hear anything after he parks the motor vehicle?
Lindsay calls the police. And then Robin said, "I'm by the back sliding door."
You can hear Robin say that?
Correct.
Okay. And do you hear anything from the defendant at this point?
He had come around back and tried to talk to Robin and say, that.
Let me ask you first of all, before we're going to what he said, how do you know the defendant came around back and was talking to Robin?
Because Robin was standing around back and I could hear their conversation.
You could hear it from where you were upstairs? Okay. All right. So you hear a conversation between Robin and the defendant at the back door?
Correct.
Okay. And can you just describe for us, please, what was the defendant's demeanor at the back door when he was conversing with Robin?
He was just trying to talk. He wanted to know what was going on. He wanted to talk to me. I think had alluded to he wanted to work something out, figure it out, that he wasn't trying to necessarily pose a threat. He just wanted to communicate what was going on.
Okay, so he was talking in a normal tone of voice.
Correct.
Okay. Was he knocking on any windows or doors at any point at this?
He had knocked on the front door.
Okay.
And then I think came around the side, but I didn't see that.
Okay. I just want to know what you could observe. Does he, to your knowledge, does the defendant come inside the Davis's house?
No.
Okay. Do you know what happens next?
Robin just asked him to leave.
And does he leave as far as you know?
Yes.
Okay. And is that in the same motor vehicle that you had been traveling with him earlier that day? Okay. Now, when you heard the conversation between Robin and the defendant at the back door, was Lindsay on the 911 call yet or not?
Yes.
She was, okay. Now, after he leaves, do you guys still remain inside?
Yes.
Does he make any further calls to you after he leaves that second time?
Yes.
Okay. And again, are you answering these calls in any way?
There was maybe 2 out of all of them that I answered, I think, or 3. But then it was, I just muted him. So they all went to voicemail.
Okay. And do you have a conversation with the defendant then?
We had a conversation where he had apologized and he didn't know what was going on. He had said that he would like to come back and I had told him no. And then he had tried to call a couple of times further and left voicemails.
And at any point, do you have a conversation with him when police were around?
No.
Okay. Does the sheriff's office eventually arrive at the Davis's house?
They do.
Okay. Do they talk to you and Robin and Lindsay about what had happened?
Yes.
Do you give any, besides verbal statements, do you give any written statements?
I don't remember.
After the sheriff's office then leaves the Davis's house, do you have any further communication with the defendant?
Not that night. He had tried to call and then text when he got out of jail.
But he called, when was this? On which day? I mean,
a day or 2 after.
Okay.
Whenever he had just gotten out of jail.
Okay. Did you ever indicate to him that you'd be willing to meet with him?
No.
Did you communicate that to him?
I communicated to him that I no longer felt safe communicating with him and to not contact me anymore.
And after you had that conversation the next day or 2 later, did he ever attempt to contact you again?
He tried to text me the same exact thing from his business phone, of which I copied and pasted my initial response from.
Are we talking about the same time period as the other call?
Correct.
Okay. All right. And then after that, any further contact from this defendant? Your Honor, that is all I have. Thank you.
Mr. Reefers, you may inquire.
Thank you, Your Honor. Not even really sure where to start with this, but we'll just go with what you had said. You were interviewed by 2 of the deputies. You remember them coming up and talking after the whole incident?
Correct.
Okay. So those 2 recordings we had, there was a lot of things in here that you had stated, but what I was following along with is we had been hanging out all day, and you had said maybe I had 1 or 2 in the early afternoon, and then maybe 3 or 4 in the evening, same amount as you. That's just going off your own words. Is that what you remember?
Yes.
Okay. Do you remember my eyes being glossy or red, bloodshot?
They were red.
We also have Deputy McClellan testified earlier when they did the other video deposition. He testified his interaction. I did not have
Objection,
glossy
Your
bloodshot.
Honor.
Okay, go ahead and finish your question, Mr. Reefers.
Thank you, Your Honor. He testified didn't have glossy bloodshot, red eyes, and I was actually compliant when I came up. What I'm wanting to
Objection, Your
know
Honor.
Yeah,
is,
Mr. Reefers, questions only.
yes, sir.
Go ahead. Working video, audio of everything that's been represented to you by Ms. Hyatt, right? Video.
Trial, Your Honor, it's good. I cannot do that with Sergeant Simpson because it immediately gets rid of the audio for some unknown reason again.
Okay, so the exhibit is going to be the full length?
For me, at trial, it was not about sex.
Correct.
Okay. And when he was leaving, what was his demeanor like?
He was upset.
Defendant. Your Honor, that is all I have. Thank you.
And you, this other vehicle you said?
Correct.
Brief your opportunity to testify, and it is not your opportunity to provide commentary about what the other evidence may show. Do you have any more questions from Ms. Burns?
Yes, Your Honor, I do.
All right, go ahead then.
Now, you had stated earlier that you, when you talked with Robin, you guys said that you wanted me to leave. Is that correct? The first time? Okay. I'm not necessarily sure how to approach this when it's on recording of her own testimony saying that she had asked me to stay and offered me some water to stay.
All you can do is ask her questions, Mr. Reefers. That's all that's
Making
appropriate.
that statement that you wanted me to stay at the vehicle? To stay there at the house?
Initially, there was conversations, yes.
Just out of curiosity, the voicemails, you said that there was approximately 20 missed calls and 7 voicemails. Did you happen to screenshot those, keep those recordings?
No.
And you were absolutely sure that it was the white vehicle that was scratched?
objection, Your Honor.
Overruled. Go ahead and answer.
No.
No further questions, Your Honor.
Anything else for this witness?
Just very briefly. Ashley, can you tell us, initially, when you first started talking with the defendant, you indicated that it was not about sex?
Correct.
Okay. And he agreed, apparently, initially?
Yes.
Okay. On November 9th of 2024, did it become about sex?
I did.
And let me ask you, when he asked you the question about wanting him to stay or offering him water, do you know if that was before or after he became assertive and grabbed your wrist?
That was before.
Okay. Your Honor, that's all I have. Thank you.
Mr. Reefers, any questions based on those questions?
No, Your Honor, I move to impeach the witness testimony based on Deputy Hale's recordings.
On the record, having concluded the testimony of Ms. Burns, procedural matter, are we going to still use the video deposition of Deputy McClellan?
I don't know if we have to anymore. That's what I was going to talk to you about afterwards as well.
Okay.
I'm trying to confirm with him whether he is available, but I believe he is now. But I'm going to double check that because then we may only need hers.
Okay. All right. So, Mr. Reefers, is there anything additional that you want to tell me about the motions other than what has already been filed in the stuff that I read yesterday?
No, Your Honor, I'd like to just submit my statement that I made for today. And
is it the same as the one you filed yesterday, or is this new?
No, this would be a new one.
All right. We'll go ahead and attach it to the order like we did the last time. Anything else from the state?
No, Your Honor, I
All
don't
right.
think so.
I did look. We are the only trial currently scheduled, so let's be in here ready to go at 8:15.
8:15 again. Okay, thank you.
So the way this works, Mr. Reavers, I know we've been through this once before, but at 8 o'clock is when the jury reports. Don't mix, there's a line. Don't mix in with that line. Wait till that line empties out, usually about 5 after, then come directly to the courtroom. You are not required to check in at pretrial on the day of trial.
What day is this, Your Honor?
September the 9th, right?
September 9th and 10th, Your Honor.
Our trial date.
I hadn't, yes, sir. 9th, 10th at 8 a.m. you said?
Yes. But again, I don't want you standing in line with the jurors.
Yes, sir. And just for the record, I object to any further proceedings. I would like the paperwork I submitted for those to have some rulings on that, Your Honor.
Okay. Did you not get notice that it was set for September the 9th?
I believe I did. I
Okay.
think it was the 27th, 9th, 10th is one of the first orders. They came
Okay.
in like 3.
Because I think we still have one more conference to get together, right? Or is this it?
We might, Your Honor. I mean, I have to pull this.
I am not aware of any conference.
Let me look. Yeah, August 27th at 10 a.m. Mr. Elter, do you have that on your calendar?
Yes, sir.
All right, we'll see everybody back here then, and we are going to trial on the 9th unless you get something in writing to me, from me to the contrary.
Okay.
Yes, Your Honor, thank you.
All right, that's all. Oh, wait. Ms. Hyatt, did you want to be heard on anything additional that is contained in Mr. Reefers' motions?
The one that he just handed me.
Nope, the one he filed yesterday.
Your Honor, I've already responded to that previously, I believe more than one occasion, so we would stand with that.
Okay. Just so everybody knows procedurally what I'm doing, I have the thumb drive that you gave me that has all of the information on it. Each time we have an email correspondence, I create a folder on that thumb drive. I download the email in an Adobe PDF format, and I also put all the attachments in that folder. So at some point, I'm going to make that an exhibit. That exhibit will have all of our communications in it, and
All that discovery.
Mr. Sarver had some exhibits that were attached to an email. Mr. Reefers had some exhibits. Each time there's an email that has attachments, I make an electronic document as that email, and I put that email and all of the attachments in a folder that I add to the thumb drive that I already have.
Can I just confirm too that on a lot of those like cruiser cams, the one, especially the 4 that we were talking about the outside audio not recording, you were told about how you go between the 2 microphones and.
I haven't looked at them.
Okay, I just want to make sure that there's no confusion. I just don't want it to come back on the morning of trial. There is a way to listen. You just have to switch microphones in order, once they exit the cruiser, then you can hear what's outside. Mr. Reefers was in our office. He was shown that, so he does agree that that worked. And so that's, I just want to make
Is
sure.
this the exhibit, the 14-minute one that we
Well,
talked
it's
about
going to
the last
be,
one?
yes, that was the thing that led me to figure out that something was going on with our Axon when we would copy them. But
that problem has been remedied, right?
it has, yes. You have a copy of what he has, which includes the outside audio as well as the in-cruiser audio. So, but the only thing is, and this is what was explained to Mr. Reefers too, you just have to switch the microphone when the deputy exits the cruiser. You switch it over to the other microphone and you can hear what's going on outside. And this 14-minute, just for the record, this 14-minute clip that I have that I'll be playing for the jury off of Deputy McClellan's cruiser cam is the first 14 minutes of the entire cruiser cam that the defendant has had a copy of. So I know he has had some confusion as to whether or not this 14 minutes is something new. It's not. It's just a clip because that's all I was preparing to show the jury. I was able to do it on Deputy McClellan's. I cannot do the same thing with Sergeant Simpson's because I know the court usually likes us to only have what we played to the jury on the CD that goes back to the jury. But I can do that with Deputy McClellan. I cannot do that with Sergeant Simpson's because it immediately gets rid of the audio for some unknown reason again.
Okay, so the exhibit is going to be the full length?
For me, at trial, Your Honor, it's going to be the 14 minutes of Deputy McClellan's. But then Sergeant Simpson, it's going to be a CD of his whole cruiser cam. But I'm only going to be playing about the first 9 to 10 minutes of it.
Okay.
I just can't clip it. That's all. So I was just trying to
All right.
make sure that's.
So, Mr. Reefers, I know that your issue is that you should have got it sooner and all of those, but right now you have working video audio of everything that's been represented to you by Ms. Hyatt, right?
No, Your Honor, I have the entire video that she's referring to, but I don't have the separate segmented 14-minute clip. I also still don't have the updated crash report. I know that's more of a trial issue, but still missing the 6 years of the administrative logs as well.
Okay. All right. Anything else today?
No, Your Honor.
Ms. Reefers, anything else?
No, Your Honor.
All right. We'll see everybody back here on the 27th.